Right, good morning everybody. The committee is resumed and we come now to the Disability Support Services Bill, and we begin with the debate on Part 1. This is the debate on clauses 3 to 6, preliminary provisions and Schedule 1. The question is that Part 1 stand part.
Madam Chair.
Honourable Louise Upston.
Thank you, Madam Chair. I would like to just make some introductory comments on this part. And remind the House that at the moment Disability Support Services operates without a dedicated legislative framework, which means that important decisions about supports, funding and service delivery don't have a level of legal clarity, transparency and certainty that disabled people and taxpayers should expect. The disability support system must be fair, consistent, transparent and sustainable. Disabled people and their families should be able to understand how disability support services works and have the confidence in how the decisions are made. Once this bill becomes law, the system will have clearer rules and greater certainty straight away. I do want to give some thanks to the parliamentary staff, and particularly to the accessibility advisors, and I want to give significant gratitude to the Select Committee for the significant work they put in, and in particular Chair Joseph Mooney for the work that you did in the process of this bill and in recommending changes that make it clearer. Although I have not watched the submissions, I've paid significant attention to them, read many of them, and my team have paid close attention. I also want to thank the team at DSS who have worked incredibly hard to ensure that the reflections and considerations and suggestions by submitters have been incorporated. So thank you to the team. During this time, I've also met with disabled people organisations and providers to make sure that we did address the issues that they had presented, and I wanted to touch on a couple of them. I do want to very clearly clarify that the bill does not broaden family responsibility. The bill says that DSS makes a contribution to disabled people and families do that where that's appropriate. That is exactly what happens today. And we do know that families' role and contribution sits alongside the contribution and support from DSS. I also want to make very clear that at no time did I ever make any comment about disabled people being a financial burden for the state, and I find that offensive. The point is that the lack of clarity without a legislative framework has created litigation and the potential for system-level financial risk. The bill does create a deliberate legislative framework to support clarity and transparency, which are things that the disability community has been asking for many, many years. And over the time that I've been the Minister, that has been the clarion call to have clarity, transparency and consistency. The bill ensures that a Minister and officials are unable to make arbitrary decisions that impact funding or services. That is a massive improvement on the past. The bill requires consultation before approved support programs are changed. It requires decision makers to have regard to statutory principles. It requires consideration of outcomes for disabled people. Actually, the bill provides a clearer and firmer basis for how future decisions are made than exist today. I will say it again. The bill does not change eligibility, entitlement or support that people receive. The bill is not changing supports. It is about establishing the legal framework that sits underneath these supports. Of course, it doesn't mean that the work to strengthen DSS stops here. Quite the opposite. It allows us to make very, very important improvements and the foundation on which those further improvements can be made, which of course benefit disabled people and their families.
Ricardo Menendez-March.
So I wanted to start with part one, the purpose of the Act. So that's clause 3. And I wanted to, first of all, test the language on 3C. So this is the mitigate litigation risk and related fiscal risk to the Crown. And the reason why I wanted to focus on this is that throughout the submissions, we have heard a lot from carers, particularly, and disabled people who they look after, on the reality that they see this provision, particularly in the sort of the purpose of the bill, which is to prevent further litigation risk, as preventing carers, particularly, from fighting for additional rights in the courts, which they can then secure and obtain greater rights and greater, basically, care. So I wanted to ask the Minister to begin with, when it comes to the purpose of the Act and her intent to mitigate litigation risk and related fiscal risk, why would she be wanting to potentially prevent carers from being able to obtain further rights through the courts? If we were to take a rights-based approach, why would an avenue be taken away from them to be able to secure the rights that they may be deemed to be entitled, some which could be, for example, be greater in line with the United Nations Conventions on the Right of People with Disabilities, or just employment matters. Because, she did make in her opening remarks the comment that she found it offensive that she sees disabled people as a financial risk, but in the purpose of the Act, there's a very explicit language here that one of the purposes is to avoid related fiscal risk to the Crown. But if we are to interpret that related fiscal risk to the Crown, it's actually greater resources for carers or disabled people, right? Because where else would this fiscal risk be coming from if it's not litigation relating to the very same rights or support or resources to carers and disabled people? So I wanted to ask, what kind of litigation risk would she be wanting to prevent? What are the things that she wouldn't want carers to be able to fight for in the courts? What are some of the related fiscal risks that the Minister could foresee that could come about carers, for example, being able to litigate and win additional rights or resources within the court system? Because ultimately, what this looks like to me is cutting an avenue for rights to be won through the courts. And so if she's going to cut that, I would like to know what are the things that she would have foreseen carers could have additionally fought for and won within the court system that could have prevented, could have resulted in a so-called fiscal risk to the Crown, as opposed to potentially a rights being earned by carers through the court system. So that's my first question. And secondly, I guess, what would she say to the people who had court cases that are outstanding in relationship to these matters, in relationship to these provisions? Does she have a message to them? Because the purpose of the Act basically, only notes one Supreme Court case, but we know that obviously there are people who would have wanted to fight this in the courts, or would have been getting ready to fight this in the court. So if she has any message for those groups of people in relationship to the purpose of the Act, that would be great. Thank you.
Madam Chair.
Minister.
I thank the member for his question, and I think it is a really good opportunity just to clarify what is intended here. There is a long-standing challenge where carers have felt undervalued, underpaid, and that's why one of the really important parts of this legislation that we will no doubt address later is support packages or support programs. And one of the first ones that I envisage will be worked on is a carer support package to resolve some of the challenges that carers face today. Where the fiscal and legal risk comes from is I want to see, and I would have thought that every member in this House wants to see, funding that's allocated to disability support services going to disabled people, their carers and family, as opposed to going to lawyers and fighting things in the court. So that is very simply what is meant about fiscal and legal risk. and that is why clarity is required. The decisions around funding sit with the government. There's been a lot of work that's been done around making sure now there are assessments that are done across the country that are consistent. Every NASC uses the same assessment process. For the first time ever, carers are now considered as part of that assessment. Is it perfect? No, it's not. We've still got more work to do. But that is clarifying the fact that we want to ensure that funding that is available is going to disabled people and their carers rather than being spent in litigation and court fees, and to make it clear that there was never an intention that MSD would be the employer of family carers. That was never the intention, and that is why it is important to address that. The question was raised about those that are currently in a legal process. They are underway, they have been saved, and those processes are underway and working through the court process at the moment. But I do want to say it is the fact that there has been no legislative framework is what creates legal uncertainty and therefore legal risk. When there is legal risk, it creates fiscal risk, which is of course something we should all be awake to.
Honourable Priyanka Radhakrishnan.
Thank you, Madam Chair. I would like to add a question to the line of questioning that Ricardo Menendez-March has embarked upon, and I would like the Minister to clarify this. Can the Minister confirm? So the Minister said just now that something about them being saved, the people who are going through the court processes at the moment, if I heard that correctly. Can the Minister confirm that this bill will extinguish 40 employment-related claims that are filed but haven't been determined or resolved at the introduction of this bill to the House? That is my first question to the Minister, and whether she can share, for the benefit of the House, what the fiscal cost was of those, or is, of those 40 claims. Madam Chair, I'd like to go right back to the start of Part 1, 3A, which, as the Minister has said in her opening remarks, the aim of this legislation is to provide a legal framework for disability support services funding. Literally nobody argues with the need for a legislative framework, not through submissions and not on this side of the House. But it is the form of this legal framework that we're here to test today at committee stage with the Minister. Minister has said in this House that there was consultation with disability communities prior to the introduction of this bill. And I would like some clarity from the Minister around that when she said that MSD has consulted, because time and again we have heard from disabled people, carers and their representative organisations that there was no specific consultation on this legislation prior to its introduction. So is the Minister then referring to consultation that was held in February, March 2025 during the review process of DSS, and then used that to inform the drafting of this legislation? So I'd like for the sake of clarity, for those in the sector as well, for the Minister to confirm that or clarify that. My second question around the purpose and the framework for DSS-funded disability support services is, I think all of us in this House knows that politics is about choices. There are different ways in which this framework could have been drafted. The Minister has chosen to codify and legislate, as she has said, what currently happens when it comes to DSS funding. And I have a few questions around that. The first is, Minister will be aware that the previous government had work underway which was to transform the disability support services funding landscape. It was literally called the DSS Transformation Bill, and it was working towards actually implementing the principles of enabling good lives, when it comes to the way that DSS funding is disseminated to disabled people. That would have transformed the type of services that disabled people and carers could access through this funding. There was also 100 million ring-fenced for that. I would like to know why the Minister has chosen to codify DSS funding that is disseminated in a way that for years disabled people have said does not work for them, instead of transforming the system when there was a framework there that she could have built on and money that was ring-fenced to be able to achieve that transformation. The Minister has said that there's been a clarion call from disability communities for a legislative framework. That is true, but there's been an even stronger clarion call from the sector to transform DSS funding, and she has chosen not to do that in this legislation, and I would like her to clarify why. I do have one more quick question that I'll get in there. The Minister has said in her opening remarks and many times that her aim is to improve certainty and transparency for disabled people through this legislation. If that is the case, why is there so little information in the primary legislation with extensive focus on ministerial programs through secondary legislation that nobody has been able to see when submitting on this bill? How does that improve either transparency of decision-making or eligibility or access of this funding or certainty for disabled people?
Honourable Minister.
There's quite a lot to go through this, so just I hope I will get through all of them. So the first thing, in terms of any of the claims that are currently lodged, they are saved. So once the legislation is passed, there will be no further ability for new claims, and they are well underway, the existing claims, in terms of being settled or resolved. In terms of consultation, one of the challenges has been, first the work around stabilising. That work to DSS has been done, and then we moved after that to look at what does strengthening DSS look like. And the team from DSS have done significant consultation with disabled people directly and organisations, and over the time that I've been Minister, I've had similar engagements where the messages around consistency, transparency, simplicity, fairness are all kind of values and principles that came through loud and clear. The other thing that came through really loud and clear is how much DSS needs to improve. And the member referred to the Enabling Good Lives principles, which were established back in 2014, 2015. And that has very much been a focus of how the bill has been established so that further improvements can be made. It's hard to improve things if you don't have the foundations in place, which is why this first bill is very much about just laying out what the current state is. And then one of the challenges has been the lack of understanding about how the current state operates, which is what we've heard in the consultation is lack of transparency, lack of understanding. It's too complex, it's not simple enough. So trying to deal with, in the first stage, getting those foundations in place and having a foundation in which things could be improved for DSS has been really important. The member raised the areas around transformation, and I would say that the improvements that we have made to flexible funding that were announced in September last year, came into effect on the 1st of February this year, really is an example of what an improvement looks like. So having a consistent assessment around the country that is transparent, where carers are considered, but really importantly, individual needs of individual disabled people are taken into account in their assessment. So that has been a significant improvement. Some would say transformational, to at least have everywhere around the country consistent, because it was grossly unfair to have disabled people in one part of the country getting a much wider range of supports and much greater funding than others. And that's exactly what we heard in consultation. That's exactly what I heard in meetings, is that it was unfair, people didn't understand it, and it wasn't transparent. So that's why it is important that we have this legislation. I want to address the member's question about why wasn't more put into primary legislation, why is it in secondary legislation? And there's this really important balance, because one of the things that is really special that needs to be protected in the disability support system is the fact that it is very individualised. And the improvements we made to flexible funding are an example of just how individualised it is. So you want to protect that flexibility, and so one of the first support programs that I envisage will be done, which is through secondary legislation, is to lock in the gains in the flexible funding changes that were announced. Because at the moment, without any protection, they can be changed overnight again. And so that's why, Madam Chair, the intention was to get the balance right of the foundations in primary legislation, but the support programs in secondary legislation. In the secondary legislation, so the support programs, there will be extensive consultation that relates to that particular support program, and we want to be able to lock in those improvements. If they're put into primary legislation, it actually makes it harder and slower to make improvements. So that is the balance of ensuring,
Minister.
Madam Chair, ensuring there is maximum flexibility, but still having the core foundations in primary legislation. And I accept that was another area that perhaps wasn't communicated well enough at the start. But I do, in many of the conversations I've had, particularly with disability organisations in the last couple of weeks, they understand that clarity. I'm trying to answer the questions that you have raised, because I think you've raised really important issues, and I do want to communicate why things have been put in secondary legislation. If you don't want me to answer, that's fine.
I'm going to take Priyanka Radhakrishnan, because I feel like these are supplementaries here.
Yes.
And then I'll come back to you.
Thank you, Madam Chair. Minister, I do appreciate your answers. I do want to hear why you've made certain decisions, and I know that others do out there as well. Just on the primary versus secondary legislation decisions here, I take your point that there needs to be a balance between the two, and I am not arguing or I'm not asking why everything is not in primary legislation, but I have looked at this legislation versus the Social Security Act, for example, which again has some level of discretion, not as much as DSS, and I take your point around that. But I think the question that disabled people have and are asking is, why wasn't there, for example, eligibility criteria? So the high level of who can access disability support services funding, I mean, that hasn't changed from 1996. So if you are codifying the current state of play in legislation, and you're not, and you've been quite clear that you don't intend to change eligibility criteria, why couldn't then some of the bones of that, who can access disability support funding, how can they access disability support funding? You have talked about the assessment and allocation tools that you have brought in for consistency, and I'll come back to that in a minute. But those sorts of things are not going to change through ministerial programs from what you have said. Why could those not have been in primary legislation to give disabled people more certainty around who can access this funding? The second point around things being able to be changed and not so much now through secondary legislation, I seek some clarity around comments that you made prior to the Select Committee hearing of this, or consideration of this bill, where you had said that they won't be able to change in the way that they did in March 2024 because Cabinet would make decisions around secondary legislation and it would be gazetted. all of those processes don't involve any sunlight or consultation with disability communities at all. And therefore, Cabinet passed the changes that happened in March 2024. Sure, they weren't gazetted, but that process, the gazetting process, only becomes public information after the process. So what happened in March could have happened again, except that disabled people came out in force at Select Committee and said that they need to be consulted when secondary legislation is passed. Select Committee has recommended that, and I understand you have accepted it and will make those changes through the committee stage, which is good. But I would like on the record, Minister, what you meant when you said that the Cabinet and gazetting process would have resulted in a different outcome to what the sector saw happen in March 2024. So keen for you to respond to that.
Madam Chair.
Minister.
So firstly, in terms of the starting from where you finished, in terms of consultation around support programs, those changes were made in the Select Committee. So the bill we are considering now has those changes in it already. So I just wanted to make that clear. One of the challenges has been without legislation, and if you look back over many years, governments of every stripe, somebody within the department, a senior official, a chief executive, let alone a minister, can make decisions at the stroke of a pen, and those changes take effect. That is why having legislation and having support programs is really important. So the support programs, with the additional consultation requirements, will mean that consultation is required in the creation of a support program. And just let me give you some examples because it links to your comment around eligibility. You will be aware today that there is no black and white eligibility in DSS. That's a good thing because it is hugely flexible. And one of the things that we must protect is the flexibility of DSS. When you look at individual funding programs, let's say, for example, hearing aids, there is eligibility for hearing aids, right? And so one of the things that I was clear about is I didn't want in primary legislation to have black and white eligibility for DSS. That is not what happens to date. That is not the current state. So it would not have been suitable for it to be included in the bill. Whereas you look at support programs, that's where the question of eligibility to do with a specific support program can and should be considered, and that is where that is important. There will be consultation, as you said, but the consultation will be related to that support program. So if we're dealing with hearing aids, not every disability organisation and every disabled person will need to be consulted regarding hearing aids. And that is why the language in the bill is carefully drafted so that the disability community don't think they're going to be, consultation overload because they're going to be involved and need to be involved in every single support program. That is not what is intended. So as I said before, there is a really difficult balance here, and I think a balance that we have struck correctly in the foundations in primary legislation, but maintaining maximum flexibility. And I had advice, very, very strong advice from people in the disability community not to make it tight and defined like the Social Security Act, because that would have had or could have had significant impacts. So it's been a delicate balance to walk.
Ricardo Menendez-March.
Thank you so much, Madam Chair. Just want to pick up on some comments from this contribution and the one pair I wanted to take a call on. First of all, I find it really hard to stomach that the Minister could even raise matters of consultation overload, where one of the reasons the Select Committee process was so heated was that there was a lack of consultation. And so, I'd love to understand what the Minister could even define as consultation overload in her eyes when quite the opposite has happened throughout the process of this bill. Which takes me back to an earlier comment she made prior to Priyanka Radhakrishna's call, which is around that she heard in consultation in relationship to sort of people receiving greater support than others. How extensive was that consultation? Because as far as I understand, there wasn't a lot of, if any, consultation prior to this bill coming through. So I just find it concerning that I keep hearing from the minister these sort of claims of consultation happening when submitters across the board have told us that they felt like they weren't included and had a full participation in helping design this bill. And I think the other comment in relation to her language is, she talks about the disability community, singular, right? I would like to challenge and test with the minister whether she accepts that there's no such thing as a monolithic disability community, which has led to a lot of the issues in the design of this bill, which is this kind of like assumption that one organization can provide a voice for a broad range of disabled people, which may not be part of it. But so that's my first question. The second one is just bringing it back to the purpose of the Act. One of the things that I wanted to get the minister to outline was around the process that she intends to use in the design of secondary legislation. We've had a lot of back and forth about what should and shouldn't be in secondary legislation. I accept that the minister has a view on what should be included in secondary legislation. I'm interested to know on whether she has already made decisions on the level of resourcing that will go into the adequate consultation and co-design with disabled people and the provisions that will be in the secondary legislation. So, for example, I want to know whether she is considering around the sort of fiscal implications and requirements that she would like to ensure are there to make sure that there's that full participation from disabled peoples around what that secondary legislation should look like. What assurances can the minister give us in relationship to how extensive the consultation will be in the design of secondary legislation, and whether she has learned from the errors of the design of this bill itself, where far and large one of the key pieces of feedback we received in the Select Committee was that there was no co-design, no adequate consultation, and that people felt aggrieved, rightfully so, because of it. Can she give us a guarantee that she and her government will ensure that there is a co-design process in any secondary legislation processes, that it will not repeat the mistakes that were found in the design of this primary legislation, where disabled people far and large felt excluded? And if she is going to take a co-design approach, can she guarantee us that she will not treat disabled people as monolithic and assume that perhaps, for example, consulting with a service provider will count as consulting with disabled people and users of those providers who may not be formally part of those organizations or bodies that provide those services? So also keen to understand, for example, what does adequate consultation or co-design could look like in the makeup of secondary legislation. I say this quite seriously because one of the key pieces of feedback as well that we received from disabled people throughout the submission process has been that, not all disabled people feel represented by the feedback given from service providers. And that's okay. Again, there's no kind of monolithic voice within disabled peoples, and so I want to understand, what will she do, the costs, the resources, whether she's already sought commitment from Cabinet on, for example, like any sort of costs that could be incurred in the design of secondary legislation, so that disabled people listening to this debate can be reassured that the same mistakes of the design of this legislation won't be repeated.
Madam Chair.
Minister.
Madam Chair, this is quite wide-ranging, and if the House will allow, I will go further than the bill just to make some of the future expectations clearer. So the first thing the member raises, absolutely. Disabled people have a wide range of needs and wide range of views. So when we talk about the disability community, absolutely. They don't all have the same opinion, they don't belong to the same organisations, and they don't all have the same views, which goes back to my comment before about the need to protect at all lengths the flexibility. that we are trying to achieve with primary legislation and secondary. So, as I said before, the Disability Support Services team engaged on a significant consultation with over 1,500 individuals coming to a variety of meetings over a 12 to 14 month period. And they heard the same messages that I did around consistency, flexibility, transparency, simplicity, etc., which is why we have built those into solving some of those challenges with this legislation. I accept that as a result of those sessions, it may not have been clear to people that the intent was to create legislation. But as one of the other members who has asked a question before has stated, that previous governments have had the intention of legislating for DSS and providing a legislative framework. So it shouldn't have been a new concept. I accept that the link between the consultation and the need for legislation wasn't made clear enough, but I can say both the Ministry and myself have not just met disability organisations and service providers. We have met with disabled people. There have been open forums for people to participate. There have been discussions with providers, as well as discussions with the DPO as the formal mechanism for consultation. And the other thing the member asked about was the consultation envisaged around support programs. One of the improvements in the bill, well, secondary legislation support programs, I'm trying to explain to people who are listening, and I will give a further example of that in a minute if the member would like me to. One of the improvements that was made in the Select Committee was the extension from 3 years to 5 for the support programs to be put in place. So my intention would be to draft a discussion document that would go out next year that would then lay out the areas these support programs would be created in, and to allow feedback from disabled people and organisations and providers to then assist in the prioritisation of those support programs. As I've said, the only two that are at the top of my list, one is around flexible funding and the other is around a carer support package. So let me use the carer support package as an example. There have been high-level conversations so far. A formal process will kick off with carers organisations and disabled people about what a carer support package would look like, to then make decisions that would then be formalised and consulted on through a support program. So I do want to reassure the House, and I do want to reassure disabled people and their families that that is what is intended as the next stage. And I would envisage that that would also then mean a second bill which adds some more of the detail and also picks up some of the concerns that were raised in this bill around complaints, around reviews and around safeguarding, which is a parallel piece of work in response to the Royal Commission of Inquiry into Abuse in State Care.
Helen White.
Thank you, Madam Chair. I want to ask the Minister about the implications of the Purpose Clause 3B, little I, little Roman numeral I. So that talks about the response to the decision of the Supreme Court in Fleming and the Attorney General, and it claims that what this bill does is clarifies the nature of the relationship. And it also, in this contribution, I am going to be talking about and asking questions about the C of that same clause, which is that one of the purposes of the legislation is to mitigate litigation risk and related financial risk to the Crown. So my questions are about a case that was hard fought and it went all the way to the Supreme Court, and my understanding of that case was that it clarified that people looking after their disabled relatives do have implied contracts, and that overnight care counts as work. So when they are doing that work, it is something that we must actually attribute to financially, and that there is a human rights alignment in this interpretation of the Supreme Court that is directly aligned with the purposes of the United Nations Convention on the Rights of Persons with Disabilities. So those are heavy and weighty things that the Supreme Court has done, and they are not in alignment with this piece of legislation. And so the first question I've got for the Minister is, does she agree they are not in alignment? That the Supreme Court has gone a completely different way on this? And so to suggest that this law clarifies the nature of that relationship, simply wrong. It doesn't clarify. We need to be honest about what's happening here. We are deciding what the nature of the relationship is, and we are not deciding it in alignment with the United Nations Convention of the Rights of Persons with Disabilities, and we're not deciding it in alignment with what the Supreme Court says would make sense in terms of our employment law. So we have things like a minimum code, and we have minimum rates of pay and leave entitlements, and we have a definition of work which covers home care workers, and so none of that is in alignment with what we're doing here. So does the Minister accept that this is not a clarification of such things? And then I want to ask about that purpose clause at C in relation to this particular point, because it says that the purpose of this piece of legislation is to mitigate litigation risk and the financial risk to the Crown. So what I want to know here is, what was the litigation risk? There were a whole lot of people, as I understand it, who were told that they would be able to take a case based on their circumstances and the work they were doing in the home, and that this stops them in their tracks and denies them financially. So what is the risk to families, and whether the Minister had advice on what that meant to other families looking after their disabled relatives, and what is that related financial risk to the Crown? And I'd really appreciate some really specific answers. What were we looking at? Sometimes we make law because we simply cannot afford the alternative. But I would like to know what, because what I've heard is the Minister stand up and say, we are doing this to create a framework, and that is a neutral thing. We are trying to shore up something that's been a bit floating, and that there's been some advantages to that process from what I've heard the Minister just say, because we can be bespoke, but we are doing this to create a framework which always sort of been there, and that's a neutral thing, and we're not taking away anything. But we are, aren't we? We're taking away potential claims by litigants that are hefty in their financial weight, and would make a big difference to families who have presumably paid huge financial cost in their pursuit of looking after their relatives. And so I'd really like an answer about that financial risk. Madam Chair, if I just could finish this.
Very quickly.
Thank you. I also would like to know about the undermining of trust here, because we've heard a lot from my colleagues formerly about the consultation and how that rattled people. But stopping people in their tracks when they are in the midst of litigation and they pursue their rights, that also causes issues with trust. And these are people who work really hard. They do jobs I don't want to do myself. I am lucky enough to be able to be here because I don't have that kind of responsibility at the present time, but it could happen to any of us. So what does she say to the issue about trust of those people? And could she please explain whether she got any advice on that, or whether she acknowledges that, in fact, for people, this will have contributed to the kind of emotional submission we got in our listening to submissions. And I did listen to those submissions. I had people who were howling, like they were crying in the corridor. So can she talk about that trust issue and whether she got any advice on it, either before she made the decisions she made or during that process? Thank you.
Honourable Minister.
I'm not going to go over territory that I've already covered around the purpose, but I do want to just reiterate that in terms of the savings of cases that have been settled or determined, that is taken care of in this legislation. Any that haven't entered that process obviously won't be able to or have not concluded. But as I said before, there was never an intention that MSD would be the employer of family carers, nor that the courts would set employment terms and conditions for individuals.
Tanushi Walters.
Thank you, Madam Chair. I am rising really to put something on the record in terms of our position relating to Crown Law's advice on the bill, and I do have the question for the Minister connected to that as well. So one of the rights that Crown Law were concerned about was the procedural right, Section 27(3)(c) of the Bill of Rights Act, which relates to every person's right to bring civil proceedings and to defend those proceedings. And the attorney in this case didn't issue a Section 7 report indicating that, in his view, there was a breach of the Bill of Rights Act. Instead, what was made public was Crown Law's advice that found that while there were prima facie rights issues, both in relation to discrimination but also procedurally, that those were justified. My read of the Crown Law advice is that there are two flaws in the assessment, particularly relating to the Section 27 advice. So firstly, there is no pure assessment of the retrospective application of the bill and how that affects those procedural rights. I would have expected that to be assessed as part of whether it was or wasn't considered reasonable under the Bill of Rights Act. The second issue is within paragraph 38 of the advice, there's a reference to or a comparison with Section 70E of the New Zealand Public Health and Disability Bill 2013, so a previous bill which had a broader bar, so it also barred future litigation. My view is that the assessment that needs to be made under Section 5 of the Bill of Rights Act, so whether it's reasonable or not, is an assessment against the current circumstances and the Bill of Rights Act itself. It's not a matter of saying that because this bill is effectively less worse than the 2013 bill, it therefore meets the threshold of being reasonable. So I think the methodology or the logic of that reasoning is flawed. I want to put this on the record because while I think there's an irony that the intention is partially to mitigate future litigation when, to my mind, this invites public law litigation and potentially an application for a declaration of inconsistency. I've called bills like this boomerang bills in the past because I expect the House may well see them returned to the House should a declaration of inconsistency be found by the courts. And I suspect that should that case proceed, then that particular paragraph in terms of procedural rights would be raised. So an invitation really for the Minister to comment on her view of that justification of reasonableness and whether the appropriate comparator is the 2013 legislation, so the less worse comparator, or whether the appropriate comparator is the Bill of Rights itself. Thank you, Madam Chair.
Madam Chair.
Honourable Minister.
I'm not going to challenge Crown Law advice, but I just will put on record for the House that the Attorney-General did do a consideration of New Zealand's Bill of Rights and found that the bill is consistent with the rights and freedoms affirmed in the New Zealand Bill of Rights Act of 1990.
Ricardo Menendez-March.
Thank you, Madam Chair. I'm mindful people may still have some calls on the purpose of the Act, but I just briefly wanted to move to 4A 1 and 2. But again, other people may want to traverse
Yeah, no,
that.
that's fine. It
Yeah,
is time, I think, that we've sort of covered
Sure.
up to 3.
I'm not privy.
So it is
Thank
time.
you. Yeah, not
it is
privy
time
to new
move
material
forward,
others
So feel very
may bring.
comfortable to do so.
That is okay, yeah. Not privy of other material others may bring. But so in my case, just wanted to focus on interpretation, which on disability support services, it talks about good services and facilities provided to disabled persons for the care or support or to contribute towards enabling them to live, and this is the language I want to test, to live their everyday life. And then it also talks in number 2, provided for purposes related or incidental to the care or support of people with disabilities or to contribute towards enabling them to, quote, live their everyday life. I'm really interested in understanding the Minister's interpretation of the quality of life that this guarantees. Because to live your everyday life could just be to be alive. It does not guarantee a full participation or a good life, that's right. Like the enabling good lives principles that disabled people have been telling us that we should actually try and follow. So I'm genuinely curious because the Minister talked about another piece of legislation that she compared this to, that she wanted to avoid creating sort of some of the issues, which was the Social Security Act. So for example, on the purposes and principles of the Social Security Act, there's this language that permeates decision making, which is to just alleviate hardship, is one of the language that is used. So for example, that is often used to justify giving someone a $20 food grant as opposed to what people actually need to live well. So when I see language here that says live their everyday life, it's deeply unclear what that means at a practical level and the test that will be applied to know whether the disability support services and or secondary legislation that is assigned alongside that actually supports disabled people to live good lives, to fully participate in their communities, as opposed to, for example, designing secondary legislation in the provision of services that simply keeps people alive but living miserable lives. You know, there's nothing stopping, like, as far as I'm aware in terms of the language, and I am not trifling with this issue because I've seen how that plays out when we design in the Social Security Act language that actually sets the bar extremely low. And it does create conditions for frontline service managers to justify leaving people without enough to be well. So for example, someone needing to gain weight for a surgery and therefore needing additional support for food, not being granted that because that's not what the purpose of or the interpretation of the Social Security Act is. So I'm really concerned about the fact that we've set the bar so low in the interpretation that it simply means to live their everyday lives. And it's hard for me to know whether that means that the Minister is aspiring or committed to ensuring that disabled people can live good lives, that they can fully participate in their communities. So I am really interested to test out with the Minister how she interprets the quality of life that is given or guaranteed to disabled people through disability support services in 4A 1 and 2. And I think this particularly matters. I know that when people end up testing this further in, say, the courts or through any reviews or through advocacy, this language, I think, will be key. And it will be used time and time again to justify an adequate provision of services because the Minister can just claim, well, you know, they're alive. So they're living their everyday life, so they're still alive. And so I want to understand what is the bar and the expectations of the quality of life that should be guaranteed to disabled people on disability support services when the legislation just says to live their everyday life. So I am very serious about this because I do think this has been one of the key things that has also come back from feedback from submitters. And if the minister is able to articulate what she means by that and the quality of life, that would be deeply useful.
Honourable Minister.
The bill does use the language of everyday life because it focuses on supporting people in the realities of their own lives, their own circumstances and their aspirations. It comes back to what we talked about before, that there is a maximum flexibility, an individual assessment of the disabled person's needs, and that's how it should be. It's also consistent with EGL and mirrors the EGL principle of ordinary life outcomes.
Honourable Priyanka Radhakrishnan.
Thank you, Madam Chair. A couple of things, just to draw a line under the questions that I had asked around primary versus secondary legislation, the sequencing of ministerial programs, and so on and so forth. I just make the point that I guess what we disagree with is the sequencing of it, and I'll leave it there. In terms of the consultation that the Minister pointed to, I would just like on the record that what disabled people and carers have been saying to us is that that consultation was around what the Minister has called the stabilisation of DSS and wasn't about the legislation, and that's the issue that has been raised. That feedback from that consultation for something different, related but different, has now been used for something else, and that is the issue that people have. I would like to ask the Minister a question around her response to my question around eligibility criteria. The Minister said that there is no eligibility criteria, and that is why there is no definition or interpretation of it in this bill. However, when you go to the DSS website, her own ministry's website, it basically tells you how to access support, and it says check if you're eligible for DSS funded support, and there is a whole list there of things that you must, criteria that one must fulfill in order to be able to be eligible for any DSS support funding. So I don't understand why the Minister said there is no criteria. Also part of that criteria is a confirmation that one must have at least one of the following: physical disability, intellectual disability, sensory, autism. Now, autism was introduced by a cabinet minute in, I think it was 2013 or something like that, and that's partially what's led to an issue because the government at the time didn't increase funding to include this expansion of autism into the expanded disability criteria. All of that points to the fact that there is disability criteria. It was set back in 1996. There's been changes through Cabinet Minute, and I would have thought that if the Minister's primary objective, as stated in documents supporting this bill, is to increase certainty and transparency, that at least that level of criteria, eligibility, and so on, could have been in the primary legislation. So want to get a response from the Minister as to why she said there is no eligibility criteria, and if there is criteria, then why wasn't at least that bit that isn't changing in the primary legislation? One more question. I've got a couple of others to get into the details of the role of families and means testing, two areas that were raised time and again by submitters, and I have some specific questions around those two. But just before I move on from the foundational legislation design questions, I would like to know why the Minister decided to club the two together. There were obviously options in the RIS to separate this into two pieces of legislation, one that responds to the Supreme Court ruling, and then one that lays out disability support services funding. The Minister's decided to join the two together, which I personally think is unhelpful, but I would like to know from the Minister why she decided to go down that route rather than two separate bills. Was it just easier, or was there something else that underpinned that decision?
Honourable Minister.
So, Madam Chair, the first thing I want to clarify is the consultation that I referred to earlier with the 1,500 individuals that participated. That was not about stabilising, that was about strengthening. So the first piece of work in the first 12 months was about stabilising. The consultation that took place that I referred to earlier was about strengthening, and this is the bill is the kind of foundations of that. In terms of eligibility, the member's reference to a cabinet minute changing eligibility is exactly why we need primary legislation and secondary legislation so it is clear. The fact that literally overnight something could change like that is, you know, in that way it was the inclusion of autism. Imagine if it had been the exclusion of something that happened in a cabinet minute. That would be horrendous. That would be absolutely horrendous. That is exactly what we are trying to prevent with this legislation. And so that's why it is important that there is greater clarity through primary legislation or secondary legislation, as I referred to, in terms of support programs.
Ricardo Menendez-March.
Thank you so much. I just wanted to pick up on the response the Minister gave me in relationship to 4A12. And again, I cannot reiterate how important the language in this bill, this bit is. So it's great to hear that the Minister interprets this clause as disabled people being able to meet their aspirations. And I just want to put it on the record that I can see now that disabled people could then, and the carers could test this with government in relationship to not just living their everyday lives, but to be able to meet their aspirations. So this is quite important, right? Because if disabled people want to challenge anything through the courts or through any reviews, they can go back to the Hansard and also note that the Minister has interpreted live their everyday lives as disabled people meeting their aspirations. And that is really critical because we often do rely on, for example, the Minister or the government of the day clarifying how they interpret, these sort of definitions of what a disability support service is. So I want to give the Minister one more chance because, again, this language will likely be continuously tested, and if she has any other language that she would like to add on what an adequate everyday life looks like, that would be useful because this again is one of the key pieces of feedback we received that people just feel like the bar's been set so extremely low that they just don't feel like the services will be adequate if it simply just is there to keep you alive. So is there anything beyond meeting your aspirations that the Minister would like to add to her interpretation of this clause that would give greater guidance to disabled people carers or actually decision makers when it comes to funding, or what her interpretation is of this clause? Because again, I cannot stress enough how much the language in this particular Clause 4 will end up mattering when it comes to the design, when it comes to discretionary decision making and or disabled people wanting to challenge any decision that is made.
Honourable Priyanka Radhakrishnan.
Madam Chair, I would like to ask some questions specifically around the role of families as defined in this legislation. And the overarching concerns that have been raised, partially responded to by Select Committee recommendations and changes made in this iteration of the legislation, but not entirely. And what is, if I were to summarise submissions, the few thousand submissions to Select Committee, most of which made mention of this point and the anxiety that people were feeling because of the role of families being codified into legislation. I will preface that by saying that I take the Minister's point that this legislation, her intention is for this legislation to reflect the status quo and what currently happens, and that is that families in the first instance do contribute to the care and the well-being and the support of their disabled family members. I understand that. However, the collective outcome or result of the definition of family in this bill, and that is in clause 4, so under the interpretation section, under family member, there is a long list, so that's 4A, not 4A, 4, anyway.
Yeah, we can see those on page 4. So
Yes,
we
on
can see
page
that
4. So
list.
it's quite an extensive list. I'm not going to read out the whole list. It's very extensive. It goes right from a person's spouse through to a person's first cousin and niece and so on. That, alongside the fact that in a later part of the bill, and I'll get to that in greater detail later, that there is initially recognition, initially the wording in this bill led people to read it quite rightly, I feel, that families had to support in the first instance, right down to your first cousin, had to step in and support a disabled person before funded support by the state would kick in. That is also then further compounded by wording in this legislation that states quite clearly that government-funded support is contributory. All of those were then read by disabled people, again, I think, quite rightly, because that was the letter of the law, the legislation being passed, to mean that if a disabled person had to exhaust all of those various avenues of family support before they could then get DSS funding, which is a massive shift from what currently happens. And the Minister has said that that is not the intention of this legislation. But the question that I would like to ask, Select Committee could only get a few changes across the line in terms of softening that language a little bit to basically state that that was not the case, but that families do have a role to play, that it's contributory to state-funded supports. The discomfort for me and for many disabled people here is that the legislation still doesn't have wording in it that gives them a clear guarantee that family support is complementary to DSS-funded support.
The members transitioning into part 2 at this point.
Yeah, that's a good point, Madam
Part 1,
Chair.
we just have the list.
Yeah, true. Okay.
Okay.
All right. So I will save this question then for when we get, the substantive bit of this question for when we get into part 2. But perhaps the Minister could clarify why the list in the definition of family member in the first part of this bill is quite that extensive. Is it so that, does it have to be detailed so that these family members can be paid, as in part B of that, and paid family carer definition in that same section? Or were there different ways to do this, to give disabled people some comfort that they didn't have to rely on their first cousin before they could get support?
Ricardo Menendez-March.
Thank you so much. Further to that, and please stop me, Madam Chair, if I'm verging into part 2 territory.
We will.
Because that's not my intention. But yeah, just following on the family member matter, can the Minister clarify whether she intends for the list of family members outlined on page 4 to be treated as a resource as well? And this, again, like to sort of the previous speaker's point, the issue around whether, and I kind of take a different angle here around whether they should be treated as a resource when it comes to the definition, because then a resource is then treated subsequently as, something that gets measured against for eligibility criteria. And is that her intention? Because submitters often talked about the need to take a rights-based approach when it comes to sort of funding decisions. And, family is, people don't see family members as something that should get in the way of having a rights-based approach. So I'm interested to know whether that list is also intended to provide decision makers with a list of the kind of people that would be treated as a resource for the design of secondary legislation as per the earlier clause we were discussing earlier for the design of secondary legislation. And when it comes to the sort of eligibility criteria that will be set out and secondary legislation. Can she guarantee to us that the list of people included in this definition will not be used as treated as a resource for the purposes of the design of secondary legislation as per the previous clause? I think that's really important because that was, again, like I said, a really key theme that came through disabled people who want to see a rights-based approach. And secondly, when it comes to the paid family care definition, I just wanted to take the opportunity to understand whether the Minister intends to further do work on ensuring that paid family cares are supported in a way that keeps up to pace with other improvements in employment policy, or whether part of the reason why there's that sort of like cutting off further litigation is to prevent paid family carers from being able to further their rights in other means. Thank you.
Honourable Minister.
I'm conscious that I've strayed outside the bill, so I will keep it very tight now. And I know that members have questions about Part 2 that I'll address then. In terms of the questions around a family member, the definition and the list is to enable payment for them under a support program. And recognition that disabled people the need to have choice around who they might choose to be a carer, and therefore supported through payment under the support program.
The question is that Part 1 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Party vote is called, please, Clerk.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT New Zealand.
11 in favour. Pardon me? Sorry, can I just correct that? It's 10 votes opposed.
10. New Zealand First.
8 votes in favour.
Te Pāti Māori.
2 votes opposed.
Tāketa Ferris.
1 vote opposed.
Marumina Kapakingi.
1 vote opposed.
The ayes are 67, the noes are 48. The question is agreed. Members, we come now to Part 2. This is the debate on clauses 7 to 16 disability support service systems. The question is that Part 2 stand part. Honourable Priyanka Radhakrishnan.
Thank you, Madam Chair. I will now get into the question that I asked previously around family care. And I mean, I won't traverse all of the detail. The Minister said she's read some of the submissions. I'm sure she's heard loud and clear what the concerns are that many submitters have raised, and it's basically that family circumstances are very varied, depending on where one lives, proximity to other family members, abuse that can also take place, and that disabled people are more susceptible to, as evidence shows, relationship breakdown, carer health needs. All of those things have been shared by disabled people, organisations and carers. And I guess the question is twofold. One is, why does it even need to be in the legislation? If the state's view is that families need to step in and need to provide care to disabled people, and therefore the state's contribution is that contributory, it's only part of the support and the care, families already do this, is what has been raised by many people. Families, by and large, if they can support their disabled family member, will do so. Why does the state need to legislate for it? Why does it even need to be in this legislation is my first question. My second question is, if it needs to be legislated for to fully represent status quo, then will the Minister consider an amendment that clarifies and provides disabled people and carers with a guarantee that family care and support will be complementary to state-funded support, that there is then no shadow of a doubt that disabled people will need to exhaust their family's ability to care for them before they can get the support that they need from the state to be able to live with dignity and independence, which is at the heart of the Enabling Good Lives vision and principles. I'll leave it there for now, but I've got a couple more questions around this.
Honourable Minister.
I want to just put on record the considerable concern and alarm that the wording in the bill as drafted created, and apologise for that. There was never any intention for the role of families to be expanded from what occurred, and I just want to put on record my thanks to the submitters and to the Select Committee for coming up with wording that better reflects what happens in the current state. So the member asked about whether or not it needed to be included at all, but because this is describing the current state, it does. And I think it's also worth recognising that, you know, many of the organisations that were involved recognise that the change to the language around families' responsibilities, where it says responsibility in the first instance, replaced with a responsibility to contribute to, and recognising that it's as well as instead of, and there's not an expectation that families exhaust their resources first. That was never the intention, and as the member raised in her comments before, in some circumstances family support isn't available, or actually it's not appropriate and it's not safe. And so that's why I think the language that we have in the bill now better reflects what the current state is, and recognises that family do have an important role, but it is alongside the DSS.
Ricardo Menendez-March.
Thank you so much, Madam Chair. So yeah, on part 2, clause 8, I wanted to also focus on the sort of the language around family whānau and other culturally recognised family groups. One thing that she did not address in my previous contribution in part 1, but I think it actually is quite suited to be debated in here as well, is whether she, and I just want to repeat it because it didn't get engagement, is whether she intends for the provisions in here to then, if families are deemed to have responsibility for the well-being of the members.
Sorry to interrupt the member, but to my right there are a lot of conversations going on, and I hope that the Minister can hear the questions because I'm actually struggling a little bit to hear them myself due to the conversations. So if you want to have a conversation, go in the lobby.
Yeah. And I think I may have heard, maybe they have some questions for the Minister too, I don't know. But look, I just wanted to test with the Minister whether that responsibility will be translated, or is her intention for that responsibility to be translated as family members treated as a resource for the purposes of eligibility of those very same services. This is key to have engagement and answer from the Minister on, because as I said, submitters have often talked about the needs for a rights-based approach. The moment that you treat the responsibility of family members as a resource for the purposes of eligibility criteria, you create the conditions where care stepping in actually undermines disabled people's ability to access some of those disability support services. And that is exactly what we want to prevent, or I want to prevent, and the Greens want to prevent, is that a rights-based approach should not then deem family members stepping in, because they want to, as a negative for purposes of any eligibility criteria. So I just want to have that stated by the Minister, what her intention is on how those family members stepping in is going to be treated in that secondary legislation. Because the other sort of unintended consequence, if the Minister does treat family members stepping in as a resource, is that if that then prevents people from accessing other types of disability support services, you could see what you see in the welfare system, which is that families feel like they have to almost try and present a breakdown in the family for the simple purposes of accessing support. And I don't think that honors the care and the interdependence that people have to one another. The interdependence that family members have to the disabled people they care for, and the interdependence that disabled people have with their families as well. And so that's my first question that has not been addressed. And I think it's really, really key. I go back to now on page 6. So this is 2B so that's 2B 2B2 around the language of a person's safety and dignity. Now, I was quite interested in the language around dignity. I mean, I've always talked about how we should treat everybody with respect and dignity, but one thing that I note is missing is full participation. And again, this is language that really matters because, full participation means, for example, a disabled person isn't just supported to stay alive or to live with dignity, but full participation means they could be resourced to participate in, for example, going to the movies, which I know sounds trivial, right? But it is like actually that enablement of fully participating in the communities that they are part of, and that includes recreation, which people should have a right to access to as well. So can I test with the Minister whether the choice of the word dignity in page 6 includes, for example, access to full participation in the communities, to recreational activities, to the things that just make someone feel like they're fully part of the physical spaces that and relationships that they want to be and part of and belong to. And if not, does she think that the omission of language around full participation is a unfortunate omission? So just wanted to test how she interprets the term dignity for the purposes of, for example, the design of secondary legislation when it comes to eligibility criteria.
Honourable Minister.
So we addressed some of the members' questions or intent behind the question in answering in everyday life. In terms of that particular statement around an eligible person's safety and dignity, I did touch on that in my answer to the previous member's question around, yes, it is a contribution, yes, families are considered, but there will be some circumstances for a range of reasons that a disabled person doesn't want to have the support of their family, or it's not safe for them to have the support of a family member, which is where the individual circumstances of the disabled person is paramount, and that won't change under this bill.
Honourable Priyanka Radhakrishnan.
Thank you, Madam Chair. So given that the Minister has said that that this needs to be reflected in the legislation because it reflects what's currently happening, would the Minister then consider amendments to change the wording not to, from the obligation to contribute in a sense, to reflect that is what families currently do, that many families, as and when they can, already contribute to the care and support of a disabled person. And also, and I point to particularly the submission by Mid-Central EGL, where they've said that ideally what this legislation should do is to also reflect the intent, so not just the language, because it currently, Select Committee has made changes to include the language of the UNCRPD and the EGL, but to go beyond that, to include the intent of the Convention on the Rights of People with Disabilities, to say that this is an obligation, or that it's an option. That families already do this, and many, when they can go well beyond, will do so. But as the Minister has said, in certain cases where there are issues around safety, that is not an obligation there. Can the legislation be a bit more explicit about this, and the fact that family support is complementary and not assumed?
The member want to refer to your tabled amendment on this issue?
Yes, I think my table amendment is currently on its way on this issue.
Oh, no, we have it.
Oh, do you have it?
Do you have? Yes.
Yes. Okay. I would like to refer to my table amendment that I do not have in front of me, but thank you.
Well, they have been tabled, so perhaps one of your team could go and get you a copy.
Yes, I have got a copy now. So that is the in essence the crux of the amendment. Thank you. Is to ensure that care is complementary and not. Can you find my actual amendment? Yes, thank you. The other question that I'll ask in the meantime is specifically related to 824, and that is around. So families, whānau and other culturally recognised family groups, where appropriate, have the responsibility to contribute. And then there's a bit that says, where appropriate, the eligible person's resources. And so these are basically what NASCs and others have to take into account when determining whether the contribution, whether, the family's contribution, and take that into account. Now, what has been raised by NASCs and others is who determines where appropriate, who determines appropriateness, and how is appropriateness determined. And that is the worry that many others have raised as well, that the disabled person may not consider their family support to be appropriate to them, but that the decision maker in this equation might. So then who makes the ultimate decision there? I do point to the changes in terms of including the choice or preference of the eligible person when it comes to determining the provision of DSS support, and that was a good change that the Select Committee has made, and a meaningful one. Also to include the eligible person's safety and dignity. But that then takes me to the other point. The Ministers said that details around safeguarding, complaints, mechanisms, appeals processes will come later, in later legislation. But the decision not to include that, those provisions or those guardrails in this legislation is what has led to a lot of the anxiety as well. So it's not just the language, and which is, is partially changed in this iteration of the bill, but it's the lack of safeguarding as well. And so can the Minister clarify her decision not to include those when this piece of legislation makes it so clear that families have a role to play to contribute to the care? So saying that the safety of an individual will be taken into account is different from having mechanisms to enable that to happen.
Honourable Minister.
So I want to clarify in terms of this legislation covering the current state. There are currently complaints, reviews and safeguarding that already occurs. So I don't want anyone to think that they don't occur. But in terms of this particular bill, we have, kept the scope of it narrow. And my expectation is, particularly around safeguarding, with the work that's going on in parallel with the Royal Commission into Abuse and State Care, there will be further improvements to what the current state is, which would be captured in the second piece of legislation. So I hope that clarifies it for it.
Ricardo Menendez-March.
Thank you, Madam Chair, and again, mindful that the member prior to me may have questions on clauses 9, 10, and 9 and 10. I just wanted to talk a bit about 11. And just particularly, I want the Minister's commitments on how she intends to use the existing income-based and asset-based criteria. One of the things that, people raise concerns about were the concerns for further or additional limitations to it. But I wanted to first of all just test whether the Minister believes in a rights-based approach, because an income-based or asset-based criteria goes against that. And so wanted to just test whether she intends or interprets the approved disability support service program criteria that may be specified to be taking a rights-based approach. Secondly, on the income-based criteria, I wanted to just test whether the income and asset base that could be used for any eligibility requirements would be just the disabled person's income and asset base, or whether any family members' income and assets could also be included as per the in the way that the legislation is written. Because again, it's not just the family members that care work that could be treated as a resource that I'm concerned about. it's a family member's income and asset based, that could also be treated as a resource for eligibility criteria that I am worried about. So I just wanted to check with the Minister what her intent or how she interprets that to be. Now, I wanted to ask her on 11.3GA on eligibility for an entitlement card issued under regulations made under Section 437 of the Social Security Act 2018, or regulations saved as if they were made under Section 437 of the Social Security Act 2018, community services card for the layperson. And I wanted to get a sense of why this was added. We were reassured that no additional limitations would be put in, but we've got this additional bit that clearly spells out additional limitations that could be put onto the criteria that may be specified. And this seems contrary to the reassurances that we've been given. I mean, this is one of the key criticisms that have come from disability justice advocates across the country when the Minister came out after the Select Committee stage trying to reassure us. Sorry, I'll just wait for the whip and the Minister to stop talking because I don't feel like, yeah. I'll just pause for a second. Okay, cool. I'll resume. So the issue I have here is that the language on GA on page 7 seems to hint at a new criteria that could be applied to the provision of services. And how is that consistent with the comments that she has made post the Select Committee process? Because I have heard disability advocates question whether her comments after the Select Committee were actually factually correct when this provision is still in place. And so I wanted to test whether CSS, the comments from CSS were correct in their assessment of her follow-up comments on sort of concerns on further restrictions to access. And to recap, just because I know we have a new person in the chair, I'm really interested in the income and asset taste and whether that could be expanded to the income and asset base of family members as well. And whether she has any hints around, for example, how broad or how range the income and asset based criteria that is specified here will be. I know that she said that she does not intend to further those, but I'm just curious, at least as legislation written, what does the future minister is able to do with these provisions? Because this bill will endure her as a minister, and I want to know what she thinks a future minister could do with those.
Madam Chair.
The Honourable Louise Upston.
As I've said previously, this is just documenting the current state in terms of means testing. So there are a limited number of programs that are related to, for example, the community services card, and so that doesn't change. In terms of what a future minister may or may not do, that's a different matter that I can't crystal ball into. But I have said on the record and will say again, there is no intention for me as Minister to introduce or change anything related to means testing.
Ricardo Menendez-March.
Thank you, Madam Chair. That's exactly what I want to get into, because I think why would she create legislation that still allows for a future minister to further restrict access to disability support services? And you know what? Like, for all it takes is a cabinet reshuffle after another leadership challenge for a future minister to be in her place and do exactly what she said she wouldn't do. Like, literally, it's the way that the bill is written, it does not guarantee disabled people that no further restrictions will be added. So why would she not have clarified that no further restrictions will be made in primary legislation? Why does she not add those safeguards in primary legislation to not just have disabled people have to take this current minister at her word, but to actually safeguard any future government from being able to add additional restrictions? I mean, perhaps if their coalition partners get to secure her ministry in the next term, what is to say that they may not want to add further restrictions into this? Does she accept at least that the way that the bill is written does leave it really open for a future minister to cause harm to disabled people by additionally, to restrict access to services by tweaking and changing the income and asset-based criteria. And so, does she accept the concerns that have been raised by submitters and by advocacy groups that the way that this is written leaves disabled people and carers very open to a future government choosing to harm and actively restrict access to disability support services? I just want her to at least be able to be upfront, not just about her intentions, but that, that a bill cannot just stand on the current minister's intention. The bill has to stand at the test of time when it comes to the protections that are afforded to groups that have had to fight for their rights in the courts, on the streets, and in Parliament. So again, does she accept that a future minister could just, as she's written the bill, just further restrict access to disability support services? And if so, why did she not deem that primary legislation would be a better place to actually add further safeguards? Finally, I know she's talked about engaging with some of my previous comments, but the one that I haven't had engagement with, and I'll just reiterate that I'm really interested in just having a bit of engagement on it, is whether family members will be treated as a resource. That is just a simple question I'm asking engagement on, whether they will be treated as a resource for the purposes of eligibility criteria.
Chair.
The Honourable Louise Upston.
So the irony in the member's question is that yesterday, the day before, for years in the past, ministers have been able to make decisions at a whim. So by the time we have this piece of legislation and we have support programs in place that will be consulted on with disabled people and the communities and families, those support programs will ensure that changes can't happen quickly. That period, admittedly, we've now extended from 3 years to 5 years to enable the support programs to be established. And my expectation is that with a discussion document early next year, disabled people and organisations and family and carers will signal where are the priorities for those support programs to be established. This does not change anything around means testing. It simply states that they exist already in a very limited number of occasions, and it would not have been accurate in describing the current state in the legislation if that had been excluded.
Ricardo Menendez-March.
And so just following up on that exchange, she often talks about not changing things that are already there, but isn't part of the issue that we're finding ourselves in that disabled people have talked about how the status quo isn't good enough, right? So when she kind of uses, hey, look, and we're not changing anything, does she concede that speaks volumes of the fact that inadequate consultation and input from disabled people has been taken on board when it comes to the fact that even the current income and asset based criteria doesn't adequately uphold the dignity of disabled people? So I just wanted to test whether the minister actually thinks that the current settings, including the lack of safeguards that have already presently existed, are fit for purpose. Because I think just saying,
we're discussing this bill, so
yes.
Can you which clause are you speaking to?
Number 11, 3, F, G, and GA specifically, just following up on the minister's answers. So the key thing that I want to test with the minister is, well, she's saying, I'm not changing anything. Does she think that the current settings then actually reflect the voices and the feedback of disabled people? Or whether she's just simply conceding to the fact that, well, not changing anything just means that, things are well and fine and no one needs to worry about. But I'll move on to so 11, 4, in relationship to the requirements that are, the things that are required to do before approving and establishing a program under subsection 1, and the fact that the minister needs to take into account the purpose of the DSS fund disability support services and the likely outcomes for disabled people of approving and establishing that program and any other matters that the minister considers relevant. I have a series of questions on this one. for the purpose of interpreting how the Minister will likely execute these provisions in the bill, would the Minister outline, for example, what are some examples of any other matters that the Minister may consider to be relevant? Does the Minister has already thought of like matters that, have either previously been considered or that she intends to further consider? And the second question I have is, when it comes to the likely outcomes for disabled people of approving and establishing the program, how will those outcomes be measured? Will it be through extensive engagement and co-design with disabled people and carers? Will it be just through sort of consulting government officials? And what happens if inadequate engagement has happened for the likely outcomes for disabled people? And this takes me to 4A around sort of the need to consult with such representative disabled persons as the Minister considers appropriate. I'm keen to understand, and I know that this is a lot of questions. I'm happy to traverse, further engagement if the Minister is not capturing it. What does the Minister consider to be appropriate level of consultation as per 11.4a? If there hasn't been adequate consultation, should any program be approved? Because that is one of the key things that disabled people have noted, that there's no protections that safeguard disabled people from a program that disabled people may deem inadequate from being rolled out, despite these requirements being in place. There's no sort of like that you must have adequate consultation. It kind of just leaves it to the Minister. So it would be useful at least for the Minister to clarify what in her view appropriate as per 4A looks like in practice, so that maybe disabled people will have a bit of reassurance of how much resourcing will go into ensuring that there's a co-design process with disabled people, or whether she thinks that maybe talking to one service provider will be enough, to be deemed appropriate consultation over 4A on clause 11. I'm really interested in, and I will have some further engagements on this because I know that this has been one of the key pieces of feedback that has come particularly post our comments after the select committee stage around disabled people's feelings of sort of inadequate safeguards on consultation, and that sort of re-traumatizing process and feeling of the errors of the bill process being then mirrored in the rolling out of these programs because of that lack of faith that disabled people currently have with the way that with the Minister and the government due to the legislative process and the lack of faith, therefore being extended to how particularly clause 11.4a will be rolling out.
Madam Chair. The Honourable Louise Upston.
I did traverse some of this area in the earlier part, which I acknowledged at the time went beyond the bill to explain the process that would go beyond this. And the example that I used at the time was in terms of consultation, if the support program was around hearing devices, for example, the consultation and the organisations, the representatives of disabled persons that would be considered appropriate would be very different for a support program around hearing devices as it would be around residential care, for example. So that is what is intended there. It is important that disabled people directly, as well as disabled people's organisations, as well as those who provide services are involved in that process. And as the member himself raised in an earlier part of the debate, the disability community is not an amorphous group and they don't have the same views or agreements, and that's why the consultation here will be important, but it won't be the same for every support program.
The Honourable Priyanka Raha-Krishnan.
I've got a few more questions that are related to clause 8 and the various things that NASCs, for example, will need to take into account when making decisions around who gets DSS. And my first question is related to 2B. Decisions about the provisions of DSS-funded disability support services to an eligible person must be made taking into account all of the rest of the things that are laid out underneath that. And I want to ask the Minister why the wording there is taking into account, which to me is rather vague and not as strong as it could be. For example, and I'd like to refer to my tabled amendment that recommends or suggests changing that to give effect to, which is stronger legal language. So that's the first part of my question. The second is related to B part 3, and that is that people who are making these decisions around DSS access or eligibility to support funding there must take into account the eligible person's immediate and long-term needs and circumstances. I'd like to know what the Minister's, I guess, what definitions would be used around that? What are the parameters that must be considered around the immediate and long-term needs? What circumstances will be in versus what will be out? And then going down to part 4, where appropriate, the eligible person's resources, is that related to income, assets that the eligible person may hold? If not, what is the thinking behind including eligible person's resources in there, and what does that actually mean? The next part of that 8.2b5, any support that is available to the eligible person from other publicly funded sources. Given that the whole point previously of disability support services transformation towards an EGL, and the Minister made a comment earlier on that she'd heard from the disability communities that various different assessment tools, allocation tools, and decisions were being made around the country where one disabled person in one part of the country would get more support than somebody else, and that's why she's brought in the assessment and allocation tools to bring in consistency, and this legislation is the next part of that work. I would put to the Minister that that has lowered potentially the access or the types of services that disabled people can access, because what we were trying to do was to transform the other way around towards the EGL sites and the ways in which funding was disseminated by EGL sites, and instead everything's been brought back to how NASCs previously were doing things. So I would put that to the Minister. But the other issue that's been raised around this is when the changes were made back, some of the subsequent changes to the initial ones made in March 2024, where, for example, children in school couldn't use their DSS funding for things like writing for the disabled, because the government's view at that point, the Minister's view at the time, was that education should be funding that, not DSS. Whereas previously, and the transformation of the move that we were wanting to make in the previous government was that the person was central to the types of services and supports that they could access. That is, in essence, the EGL vision. This legislation just imports some EGL language, but not the intent or the vision of the Enabling Good Lives approach. So is that what is now being captured in legislation in Part 5, Minister, where any support, if there's support that comes out of the education pot or the transport pot or the housing pot, that this will then, my fear and the fear of many is that this will lead to the further fragmentation of the type of support that disabled people can get, and not a better, more cohesive package of money that actually transforms a person's life and makes it better. So I'll leave my questions there for that.
Chair. The Honourable Louise Hubston.
I keep getting into trouble with going further than outside the bill, but let me just, in terms of the questions that the member asks, the principles of EGL are absolutely reflected through the section here, because if you think about the eligible person's immediate long-term needs and circumstances, one of the things that we do want greater consideration of is investing early. So the social investment approach, which might mean when considering some persons, a disabled person's long-term needs, actually there might be different assessments made around what support is available now. And an example of that is the powered wheelchair research that's underway at the moment. In terms of your question around other government departments and support that's available, that is also one of the EGL principles about mainstream access. And so access should be equally available to health for disabled people. Let me explain. So health is, should be accessible and available to disabled people, and clearly there's improvements that we need to make across the board there. The changes that were made to flexible funding that started in the February the 1st, took away all the guidelines, took away all the rules around flexible funding to maximise disabled people's choice and to ensure that they are able to access the services and supports that they require.
Helen White.
Thank you, Madam Chair. I would like to dig down on the wording in Clause 8, which is about where appropriate. And my colleague touched on it, but I want to kind of dig down into this issue as it arises in 8(2)(b) Roman numeral little iv and also Roman numeral little vi. So my major concern would be with the first of those, but it is a principal question. Here we have a clause that says that one of the criteria is where appropriate the eligible person's resources. And then we have another which is where appropriate any support that is available to the eligible person, including their whānau, other culturally recognised family groups in their community. Now, that looks to me like there's a lot of capacity there to decide what is appropriate. What I'd like to know is what is meant by where appropriate. When would it be appropriate and when would it not? And what kind of restrictions is there on the minister changing what that criteria is through that pathway of just simply deciding that it is now appropriate and moving a lot away from the status quo into something that is much more burdensome on both that person's resources and their family and community. So, for example, we had the minister talk about how that wasn't her intention at the moment. She was categorical in the House that her intention was that there would be no means testing beyond the point it is now. But does she accept that that particular wording is permissive? And what kinds of constraints has she put in place to hold firm to her assertion in the House that that would not be happening under at least her watch? And what kind of constraints has she put on others in her role in this piece of legislation if it is her intention that this is not the beginning of an increased use of means testing or becoming overly burdensome on family and community in a way which actually means that people are being asked to do something that's simply burdensome to the point of becoming dysfunctional. So I appreciate, I work in the, one of my portfolios is community and voluntary. I appreciate that the community steps up so many times in this area, but I also appreciate that it often fails in those situations because of a scarcity of resource, often from actually government funding, but also because it's hard out there and there just isn't the money to support the organisations the way they were. We're seeing a dip in giving. So we do not have those kinds of resources available in the community anymore. I'm also aware in areas that are well beyond the scope of this bill, so things like
then we won't be talking about it.
Well, no, it's important because it does relate, I promise, Madam Chair. We have a situation in something like Oranga Tamariki where there is a pushing out to whānau and pushing out to community when that resource is not there and it is known not to be there. And that can happen in a situation where we're trying to stop the burden coming on to the state. We can push to these places that just don't exist. So I am aware that in these situations, it's a problem that's systemic that we push out. And we can say it's appropriate when it's actually just simply factually impractical. So I would love the Minister to tell me what is the constraint on the use of that beyond what is actually really appropriate. What kind of stop has she put on others misusing this, even if she has made a binding commitment in this House to it not being used in that way? Those are my primary questions, and that use of the language where appropriate. Did she have advice on that? Because that really concerns me, that there is so much wiggle room in it, even if the Minister is bona fide trying to do the right thing. And so what was the purpose of using that wording? Why does it need to be so wide? Thank you.
Has expired. Before I take the next call, I've been in the chair a short time, and I believe we have thrashed clause 8.2, so am looking for new material, please. Ricardo Menendez-March.
Thank you very much. Just a question on definitions in the bill, and this will be a very brief stuff on I note your comments, but one thing that I wanted to note that seems to be not defined in the bill is there's a lot of definitions for what family member is. So this is on 8, my final contribution on 8, so I will move on immediately after, but just wanted to note that there is quite a broad, there's quite an extended definition of what a family member is considered, but there seems to be no definition of what a community is for the purposes of this bill and the DSS funding services. I'm concerned that we have this kind of thing where community is just left out, not really defined. And I wanted to get the Minister's views of what decision makers could be using. Well, you belong to a church that runs Sunday programs, and that counts as a community, like stepping in for you. Would it be like, hey, look, in your neighborhood, there are volunteer-run programs that exist, say, 3 blocks away from where you live. That counts as a community for the purposes of the resources that exist. Could it be that in small rural areas, just somewhere in your whole township that provides some sort of support is considered community for the purpose of eligibility criteria? Because we have quite an extensive definition of who is and is not sort of like a family member, but I'm concerned about the fact that community just doesn't have that. And the reason why I think this is quite important is that if we look at other acts where, for example, people are asked to look outside for support that could be met. So, for example, the Social Security Act, we often have case managers saying, well, have you checked out this food bank that exists several sort of neighborhoods away before we give you assistance? And so, it's really broad, like how, for example, in the Social Security Act, that sort of those provisions around have you checked for other support first before we give you support covers. And I am really concerned that community is just left out so broadly. I am none the wiser of how that will be interpreted when it comes to DSS funding decision making. So if the Minister would like to elucidate on what her definition of community is and how that could be used to the detriment, if at all, of disabled people, I'd love to know, because I do think that is really, really important criteria. Now, moving on to clause 11, and just signal to the chair, the only reason I would go back to it is if I don't get engagement from the Minister, but on the community definition. But on 4A, so that's on page 8, something that the Minister did not engage with in my previous comments was just on a reassurance that, that no program will go through without adequate engagement and co-design with disabled people. Because again, that's one of the key tensions that has existed post the Select Committee stage and the reassurance that the Minister has given. I note that, the minister's apologised for, say, the process, the hurt, what has occurred in this legislative process. But this 4A on page 8 is, in my view, the place in which those mistakes could be redressed by giving a reassurance that no program will go ahead without an adequate co-design process. Because otherwise, what we have heard from the likes of Dr. Hanahiki from CSS and others is that, the minister can just kind of claim, well, I talked to one service provider and that is good enough. I know that the minister said in previous comments, I've already addressed that, I agree with Ricardo, the community is not monolithic, that there's many views, but that doesn't really address or engage with the matter of whether programs could still go ahead without a high bar of consultation. And so if the minister would engage with 4A specifically and what bar and standards she wants to set before any program gets rolled out in terms of the level of co-design, and what, for example, representatives of disabled people mean, because representatives of disabled people could be someone who's not disabled. It doesn't necessarily, you could literally talk to a bunch of able-bodied people who are not disabled, who deem themselves as representatives, and the program could then be rolled out. Could she please set the standard that she wishes to use for the purpose of 4A, and to recap, what does she define community for the purposes of
members' time has expired, and just to reiterate the point, this is my second warning about repetition. Even though I did make that clear before the member stood up, he has repeated 2 items that were previously answered by the minister. So please don't argue with me, Mr. March. I am explaining myself. Repetition is not getting us anywhere. You are going to get the same answers to the same questions. Does the minister wish to respond? The Honourable Willow Jean Prime.
Thank you, Madam Chair. And this is my first call in the entire debate, so I'll just point that out. And this is new material which the minister has not addressed. I am anxious to give it because it does relate to the definition of communities, which is the clause 8 that you're warning us to move on from. But it is relevant to the points that I also want to make about another section. So I hope that the chair can give me the ability to do this, because what I am wanting to raise here is the lack of any reference in this legislation to te tiriti or waitangi, and the impact of these legislative changes on Māori. And I'm referring in particular to a submission from Te Ao Marama Aotearoa, who represents tangata whaikaha and their whānau, who in their submissions point out how disappointed, how upset they are that they were not consulted at all in the development of this legislation. And they have concerns around the wide definition of community and the impact on concepts and tikanga like whanaungatanga that are important in terms of clause 8, but also their concerns around the lack of consultation in the development of this bill, and talking to clause 11 4A, where it says that the minister must consult. And yet we didn't see that consultation happen in the development of a very significant piece of legislation, a huge change in a generation, essentially, with no references to te tiriti or waitangi and no engagement with the representative body of tangata whaikaha and their whānau. So they point out that the Crown is obliged to engage with them directly under te tiriti or waitangi and many other conventions that we are part of, and they did not. And they also said that when it comes to the conscription of whānau in clause 8, I just want to read the submission and see if the minister has any response to this. They say the communities with the most expensive conceptions of collective responsibility, our communities, carry the heaviest statutory expectation
while the Crown that drafted the clause carries none. No duty to assess whether the presumed support exists, is safe, is sustainable, or is consented by the whānau or the disabled persons. No training, no respite guarantee, no income protection, no limit in scope or duration, no point at which the obligation is fulfilled. The point they make is that whanaungatanga is a taonga. It is not fiscal infrastructure for the Crown to draw down, and aroha is not a substitute for the state meeting its obligations to disabled citizens. Madam Chair, in terms of the clause 11.4a, before approving and establishing a program under subsection 1, the Minister must also consult such representatives of disabled people as the Minister considers appropriate. Does the Minister consider Te Ao Marama Aotearoa, the representative organisation for tangata whaikaha, me o rātou whānau, as a disabled person she considers appropriate to engage with? Why did she not engage with them in the development of this legislation? Will she engage with them under that particular section? And will she reconsider the fact that they do not have any reference to Te Tiriti or Waitangi in this legislation, and as these submissions point out, what the need for that is?
Madam Chair.
The Honourable Louise Upston.
I've answered questions around consultation and the creation of the bill. I've answered questions around consultation going forward, and I've answered questions about family.
Come on, what about Māori?
Priyanka Krishnan.
You, Priyanka.
Oh, me? Oh, yes, okay.
Sorry, I wasn't looking at the mic, so it disappeared.
All good. All good. Madam Chair, I would like to ask the Minister some questions around clause 10, and that is the ability for the Minister to give the Ministry binding directions. And this is the section of the legislation that allows the Minister to create, through secondary legislation, ministerial programs or support programs, which basically contains all of the detail that disabled people and carers are interested in and wanting to see. I will note the Minister's comments earlier on in this debate. We did have a bit of a back and forth on decisions around the line between primary and secondary legislation and why so much of this detail the Minister's decided to put in secondary leg instead of primary. So I won't traverse that bit, but what I do want to ask the Minister is that given that the authority to make secondary legislation is, both by convention but through the Public Legislation Act from memory, the guidelines around that is to be really careful about the level of detail, technicality and complexity that ministers put into secondary legislation. And I mean, if I look at DPMC's own website, and I'm looking at this because in 10.3, it basically says to see Part 3 of the Legislation Act 2019 for requirements around publication. And this is to the Minister's previous point where she stated that her decision to include all of the detail around support programs in secondary legislation rather than a mix of primary and secondary is to give people comfort that things can't be changed very quickly. So I'd like to tease that aspect of it, of the Minister's comments out in this particular, through this particular clause. Guidelines is basically that substantive policy shouldn't be in secondary legislation, that it should just be, for example, the amounts or the thresholds that need to be changed that can be in secondary, that should be in secondary legislation. But the specific types of support programs that people can access should be in primary leg so that they cannot be changed quickly and without the oversight of Parliament. So can the Minister give us some clarity around that latter part of the point, of that point? Disabled people who've been submitting to this, who've been listening to debates in the House around this, don't feel a level of comfort because it's easier to change secondary legislation than primary legislation. I also understand that there are specific language that could have been, that the Minister could have used in this legislation, in this particular clause, to require the Regulations Review Committee, and I understand that my colleague Aotearoa Williams would like to speak to that a little bit further, but that could have then given people some comfort that changes cannot be made to support programs quickly. So can the Minister clarify why she said that, given that secondary legislation is easier to change than primary legislation?
The Honourable Louise Upston.
We have traversed this in the earlier conversation around flexibility as one component. And the other thing I would point out here in terms of Clause 10 that the member is referring to, and this is also about how the Ministry performs its duties. And without traversing history, I think there are many examples of how it was previously set up that it didn't perform those duties anywhere near well enough.
Helen White.
I would like to talk about the employment provisions here. So I'm looking at clause section 12, and I have a background in this area, and so it is of great concern to me when I see clauses like clause 12.2, which talk about if A is a party to or covered by a written agreement with the Crown stating that A is an employee, the agreement is conclusive proof that A is an employee of the Crown. Now, my problem with this is employment relationships are a matter of fact. We have some very strong rules about what those things look like in the real world. And we also have a long-term relationship here, just like many employment relationships, and things morph. They change significantly in that time. And employment law has always recognised that reality versus anything that's written down. And I'm concerned that here we have a very dangerous, it's not really a precedent because it's also being done with contractors, this idea that writing overrides reality. So in these situations, we have a whole lot of people who are working their socks off, and we are deciding what they are as a matter of the signing of a document, when in employment law we recognise that the reality morphs over time. We also recognise that there is a power imbalance in these situations, and I couldn't think of anything more likely to have a power imbalance in it than this particular relationship where people are trying to look after their loved ones. They really don't have a lot of choice in what they sign at that point. They are actually in a position of deep moral quandary. So I wanted to know from the Minister what she looked at when she looked at that issue of the consistency of our country's moral approach to work and the issue of power imbalance, which is built into our Employment Relations Act. It recognises it straight up, and then all these other things hang off it. But we don't recognise power imbalance in this relationship. Why not? Is what I'd like to know. And I'd like to know what safeguards there are with regard to that power imbalance. In other situations, for example, even the contractor situation, we have often a reliance on independent legal advice. Is there anything going on here like that? Then I have an issue with regard to that relationship choice. Were there other options about the way we could handle this relationship that would not have excluded this community from that employment paradigm entirely? And if there's a dispute, what happens? What happens in that situation if there's a dispute about the way that people are treated? We have a whole scaffolding in employment law around that. What's going to happen to these people if there are issues that emerge in terms of the way that they are treated? So I also asked questions about this when we were in the select committee about the issues around that employment treatment and the savings that were associated with excluding this group of workers from that scaffolding of employment. I asked questions about how much the government would save, and I'm asking you those questions now. How much does the government...
I don't answer.
Sorry, Madam Chair, I'm asking the Minister to talk and be transparent about how much money the government saved in this circumstance, but also how much there is an unintended consequence of people simply refusing to do this work in these conditions, and that work being bounced into institutional care or other frameworks for care because they cannot do it. Is there a risk of economic impact with regard to that, and did she do some work on that? Thank you.
Madam Chair. The Honourable Louise Upston.
I spoke about this earlier in terms of one of the priority pieces of work being the future carer support package, which basically would resolve many of the issues a member raises.
Aaron Williams.
Thank you, Madam Chair. A brief call for the Minister. I just want to ask her about her comments that the directions will allow her the flexibility. It's the other way. I want to ask about why it is formal and formally recognised as secondary legislation when the option for her was obviously then policy, which would not be secondary legislation. The directions in this Act are similar in nature to the old system. Commend the Minister for this framework, which, as she quite rightly points out, didn't have a legislative basis before, so the directions were more akin to the immigration instructions, in that they didn't have a legislative effect, but they were something more binding than departmental policy. The amendment in the name of the Honourable Priyanka Radhakrishnan that we have suggested to clause 10 after 3 would make these confirmable instruments, which would give them the same status as confirmable instruments, which are a more commonly used tool to give ministerial directions. When the Regulations Review Committee confirms instruments, its only check is that they are made in line with the purposes and objects of the Act. That is what this Section 10 purports to do, but there is no check that the directions do in fact realise the objects and purposes of the Act. So my question is about, well, if it is her intention to make the directions secondary legislation, then what is the check and balance to ensure that that secondary legislation is made within the purposes of the Act and that it's not ultra vires to the Act? Policy can be extra to the legislative framework. This is not policy. So the choice here to make it legislative in effect binds the public service in a way which you're only able to do at this level, at the parliamentary level, if it is in line with the legislative intent. We're having a debate right now about what the legislative intent is, so it's also useful to be clear about what the checks and balances are to keep it in line with that intent. Or the alternative then is that it's meant to function more like the immigration instructions. Madam Chair.
Honourable Priyanka Radhakrishnan.
Thank you, Madam Chair. I have a few questions to the Minister on Clause 11, and they are related to tabled amendments of mine as well. This particular clause brings into the debate issues around income testing, means testing, asset testing, and that is another area that many have expressed significant levels of discomfort and anxiety around. So I would like to test a few things with the Minister with regard to this. And I won't go into the details, but it's across clause, the various parts of Clause 11. The Minister has said many times that the inclusion of income and asset-based criteria in this clause is only meant to reflect where it's currently taken into account, and that is in very few circumstances. So, I mean, I would ask the Minister to consider my tabled amendments to remove them completely, to give disabled people comfort that they will not be means tested before DSS support is made available to them. But in the event that the Minister does not want to take it out completely, because it is currently criteria for specific things, I would suggest or draw her attention to my tabled amendment that is to replace in clause 11.3g after criteria, to then be specific about what this current criteria for income and asset testing refers to. Specifically, the community services card for hearing aids, home modifications or vehicle modifications. From memory, those are the only areas that the Minister has said is currently means tested. If that is not the case, I would like the Minister to clarify what other areas are currently means tested, and I'm happy to include those in my amendments as well. But that will then give disabled people absolute surety and certainty, which is what the Minister wants to achieve out of this legislation, that it will not then be used to means test further types of disability support funding that they can access, because those changes can be made in this through clauses 10 and 11 in future support programs. My next question around criteria for the Minister is reflecting on our previous discussion as to why eligibility criteria more broadly, as laid out on her own ministry's website, is not included in primary legislation. The Minister said firstly that there was no such thing, but also that her decision there was to ensure maximum level of flexibility. Now, reading clause 11 in its entirety, it occurs to me, and I put this to the Minister and would like her to either confirm or clarify, I put to the Minister that her decision not to include DSS eligibility criteria in primary legislation is so that it can be changed for various types of support, which is again a departure from current practice. Currently, if you're a disabled person and you meet some of that criteria that is currently listed on the Ministry's website, you have specific types of disability, the NASC will assess what particular supports you need based on your disability and then give you a support package that will allow you to access the support that you need to be able to live an ordinary life, presumably. Now, not including that in primary legislation, but saying in clause 11 that there will be different types of eligibility criteria for different types of disability support is anxiety-inducing, because at this point, although the Minister has repeatedly said that this legislation does not change current eligibility or entitlement today to DSS support, this indicates that it will change. This indicates that the Minister, through secondary legislation, can change the criteria for, say, community-based support versus residential support or flexible funding. So the Minister's shaking her head, which is good if that is not the intention, but can she please clarify how else anyone is meant to interpret this legislation other than the interpretation that I have just put to her?
The Honourable Louise Upston.
We're going over the same ground again, so I'm not going to traverse that. And in terms of means testing, it would not be an accurate reflection of the current state if it had been excluded from the legislation. That is why it is included, and it has been amended to make it clearer as a result of the Select Committee process.
This is my final warning on repetition. We have traversed up to clause 12 and we are moving on. Ricardo Menendez-March.
Thank you, Madam Chair. I wanted to speak to Priyanka Radhakrishnan, tabled amendment tabled at 9.13.07 that hasn't been spoken about yet. So bringing some new material to it. This is the deletion of clause 11.4bb, which I haven't spoken about 4b and clause 11 myself yet. I don't think anyone has. So on 4b and particularly looking at 4bb, first of all, I want to know what is the Minister's justification to have the ability to basically override the provisions in 4A, which are about consultation, or just that, or basically to say that there's a must consult with disabled people, but actually in 4B, you know, like failure to comply with those consultation requirements does not affect the validity of any program. Can you see why 4BB makes 4A a little bit sort of not, doesn't give any teeth to the provisions in 4A? Because basically, why would the minister have a requirement to consult to then have a provision that says, well, actually, but if it doesn't happen, it doesn't really change anything. So can I get a sense of the minister's intention for why having a provision in 4BB to say that, look, at the end of the day, if you do not comply with any of this consultation requirements, the program is sort of can go ahead anyway, which takes me to the point that, you know, if the minister is genuine about being able to consult, well, sorry, not able, but having a requirement to consult, why wouldn't she support Priyanka Radhakrishna's amendment that seeks to delete clause 11 4BB? And if she doesn't support it, I'd love to know what her justification is for just simply scrapping those consultation requirements. Which takes me to a final point just around that I haven't had engagement with the minister, which is whether the term representatives actually includes disabled people, or whether it can include non-disabled people who, or can, you know, whether the minister would be satisfied if she only consulted with able-bodied people that seek to represent disabled people for the purposes of 4A. So again, I just don't understand why you would have this interaction between 4A and 4BB, which seems to just sort of allow the minister to ignore disabled people or their representatives anyway. So any comments, justification, or indication of support, indication of support for the amendment would be very welcomed.
The Honourable Louise Upston.
Where there's a minor in effect issue that wouldn't be consulted on, for example, could be where there is an increase in a rate. So you wouldn't go out with wide consultation where a rate is being increased. Clearly, if there were changes the other way, that would not be minor, that would have an impact, there would require consultation. So that is an example.
Carlos Strong.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour, please say aye. Aye. To the contrary, no. The ayes have it. Party votes called for, Mr Clerk.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kau ngā pōti whakahe.
ACT New Zealand. New Zealand First.
8 votes in favour.
Te Pāti Māori.
E whā ngā pōti whakahe.
Tāku Te Ferris.
Kotahi te pōti whakahe.
Maramian of Kapkingi.
Kotahi te pōti whakahe.
The ayes are 67, the noes are 50. The question is agreed to. The question is that Honourable Priyanka Radhakrishnan's tabled amendment to clause 8 brackets 2 to replace take into account with to give effect to be agreed to. All those in favour, please say aye. Aye. To the contrary, no. Aye. Noes have it. Aye. Party vote, please, Mr Clerk.
New Zealand National.
48 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kau ngā pōti whakaai.
ACT New Zealand.
11 opposed.
New Zealand.
8 opposed.
Te Pāti Māori.
E whā ngā pōti whakaai.
Tāku Te Ferris.
Kotahi te pōti whakaai.
Miriamana Kapkingi.
Kotahi te pōti whakaai.
The ayes are 50, the noes are 67. The question is not agreed to. The question is that Honourable Priyanka Radhakrishnan's tabled amendment to clause 8 brackets 2 brackets A to insert words after members be agreed to. All those in favour, please say aye. To the contrary, no. No. Noes have it. Party vote, please, Mr Clark.
New Zealand National.
48 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko ngā pōti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E whā ngā pōti whakaai.
Tāku Te Ferris.
Ko tahi te pōti whakaai.
Ria Manu Kapakingi.
Ko tahi te pōti whakaai.
The ayes are 50, the noes are 67. The question is not agreed to. The question is that Honourable Priyanka Radhakrishnan's tabled amendment to clause 8 to insert new paragraph C into subsection 8 brackets 2 be agreed to. All those in favour, please say aye. To the contrary, no. No. Noes have it. Party vote, please, Mr Clark.
New Zealand National.
48 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko ngā pōti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E whā ngā pōti whakaai.
Tāku Te Ferris.
Ko tahi te pōti whakaai.
Ria Manu Kapakingi.
Ko tahi te pōti whakaai.
The ayes are 50, the noes are 67. The question is not agreed to. Honourable Priyanka Radhakrishnan's tabled amendment to clause 10 is out of order as not being in the correct form of legislation. The question is that Honourable Priyanka Radhakrishnan's tabled amendment to clause 11 brackets 3, deleting paragraph F, be agreed to. All those in favour, please say aye. To the contrary, no.
No.
The ayes have it.
Noes have it.
A party vote, please, Mr Clark.
New Zealand National.
48 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko ngā pōti e whakaai ana.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E whā ngā pōti whakaai.
Tāku Te Ferris.
Ko tahi te pōti whakaai.
Ria Manu Kapakingi.
Ko tahi te pōti whakaai.
The ayes are 50, the noes are 67. The question is not agreed to. The question is that Honourable Priyanka Radhakrishnan's tabled amendment to clause 11 brackets 3, deleting paragraph G, be agreed to. All those in favour, please say aye. To the contrary, no. No. Noes have it. Did they call for a party vote? Did they call? Was there a party vote called for?
Yes.
Okay.
New Zealand National.
48 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko ngā pōti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E whā ngā pōti whakaai.
Tāku Te Ferris.
Ko tahi te pōti whakaai.
Ria Manu Kapakingi.
Ko tahi te pōti whakaai.
The ayes are 50, the noes are 67. The question is not agreed to. The question is that Honourable Priyanka Radhakrishnan's tabled amendment to clause 11 brackets 3, paragraph F, restricting income-based criteria for matters relating to community services card be agreed to. All those in favour, please say aye. To the contrary, no. No. Noes have it. Party vote, please, Mr Clark.
New Zealand National.
48 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko ngā pōti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E whā ngā pōti whakaai.
Tāku Te Ferris.
Ko tahi te pōti whakaai.
Ria Manu Kapakingi.
Kotahi te poti whakaai.
The ayes are 50, the noes are 67. The question is not agreed to. The question is that Honourable Priyanka Radhakrishnan's tabled amendment to Clause 11, brackets 3, paragraph G, restricting asset-based criteria for matters relating to community services card be agreed to. All those in favour, please say aye. To the contrary, no. No. Noes have it. Party vote, please, Mr Clark.
New Zealand National.
48 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kou ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E whā ngā poti whakaai.
Tāki Te Whereas.
Kotahi te poti whakaai.
Miramena Kapakingi.
Kotahi te poti whakaai.
The ayes are 50, the noes are 67. The question is not agreed to. The question is that Honourable Priyanka Radhakrishnan's tabled amendment to Clause 11, brackets 4B, deleting paragraph B, be agreed to. All those in favour, please say aye. To the contrary, no. No. Noes have it. Party vote, please, Mr Clark.
New Zealand National.
48 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kou ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E whā ngā poti whakaai.
Tāki Te Whereas.
Kotahi te poti whakaai.
Miramena Kapakingi.
Kotahi te poti whakaai.
The ayes are 50, the noes are 67. The question is not agreed to. The question is that Part 2 stand part. All those in favour, please say aye. Aye. To the contrary, no. No. The ayes have it. Members, we come now to Part 3, which is the debate on clauses 17 and 18, miscellaneous provisions and Schedule 2. The question is that Part 3 stand part. The Honourable Priyanka Radhakrishnan.
Thank you. I have a couple of quick questions for the Minister on this part, and all of it relates to Clause 17 and the review that will need to be undertaken at the conclusion of 5 years. Also, I guess, take the Select Committee's recommendation to shift the transitional period from 3 years to 5 years to enable for the consultation that is now required in this bill to take place, although the Minister had said she was going to consult anyway, but now she has an additional 2 years to do that. My questions, though, are related to 17.1a and the review of the operation of this Act, and I would like to ask the Minister what she envisages that review to include. Will it just be whether this Act is working, which is how I would interpret that particular part of this clause? And given that a bulk of the detail is in the secondary legislation, will the review also include whether those support programs are working, bearing in mind that the Minister's intention is to have that, or at least some of them, concluded, presumably by the end of that 5-year period, or will it be all of the support programs concluded via secondary legislation at the end of that review period? So I'd like some clarity around what the review will actually include. I would also like to know whether the Minister intends for there to be consultation with disability communities in that review process as well. And the reason that I ask this is because I would like to know whether the review and the report that results from that will include a reflection on whether this legislation, given that the intention of the Ledge is to provide a foundational framework for DSS funding, but ultimately it is to ensure that disabled people and carers are supported to be able to lead, in the words of this bill, everyday lives. Will that be included in the review? Will it actually look at whether this legislation is working for disabled people, carers, and the disability community more broadly, rather than just whether the letter of the law is functioning in an operational sort of manner. So that's my main question to the Minister. I'd also like to know in B, 17.1b, where it states that there should be consideration as to whether any amendments to this Act are necessary or desirable, whether that will also take into account secondary legislation as part of that review.
Madam Chair.
The Honourable Louise Upston.
Madam Chair, I want to thank the Select Committee for their work, particularly on this part, which created the inclusion of the review of the legislation after 5 years and increased the transition period from 3 years to 5. So clearly a review of any legislation would need to consider, is it acting as intended? And I think that's particularly important because there has been no legislation in this space already. My expectation is that it would, of course, review or include in its scope support programs that are secondary legislation. Not all of them would have been in place for long enough, so perhaps wouldn't make sense to review all of them, but any of them that were in place would make sense. The other thing that I had indicated, which admittedly is out scope of this legislation, but I had talked about an intent that there would need to be a second DSS bill to look specifically at some areas that have been raised. So a second bill would also mean if there was anything in this piece of legislation that was clearly not working already, it could be picked up at that stage. But what is the intent behind this legislation? What is the intent behind support programs, specifically the ones I've talked about in terms of flexible funding and carer support package, is absolutely to make DSS better than it is today. Why do we care about that? Well, because we want to improve the lives of disabled New Zealanders, their carers and families. So yes, that would be part of the review. Law clearly wasn't going to be working as intended unless disabled people, carers and their families were seeing an improvement in their lives.
Arana Williams.
My questions relate to Clause 18 and the consequential amendments. First is a more general question to the Minister. I think she was helpful in her elucidation about the purpose of the review, and the answer might be the review to this question, but this is a devilishly complicated piece of legislation in the way that it deals with secondary legislation and confirmable instruments that exist within the system. That's the purpose of the legislation, is to deal with all of the things that have grown up that are sort of regulatory-like within the system. So the consequential amendments section, it seems light. And I want to ask her whether, what advice she has had from officials that the consequential amendments are the whole suite of legislative changes which will be needed to be made to other acts. What has been her process to ensure that we are capturing those people who have already had a decision under the law that is a legal decision now, but under her new law will not be a legal decision and will rely on outmoded legislation. So that's the first question. The second question is particularly about the ministerial directions. So I think that her new clause 10 makes ministerial directions that have happened prior to the commencement of this Act secondary legislation. So my question is, does this Act amend secondary legislation by giving directions which were policy now the status of regulation, or is it the case that she will need to reissue all of the ministerial, what are now directions, but were policy? To give you an example of this, programs that the ministry would have been responsible before are now secondary legislation. So do they sort of automatically count as new law now, or do they need to be reissued? In which case, shouldn't they be in the consequential amendments part? Should there not be amendments which sort of list out all of those pieces of now what are secondary legislation? And the reason I ask this is because, the real world impact is that somebody's house that is partly funded under health and partly funded under the new system will rely on a ministerial direction that didn't have the status of secondary legislation until this Act is in force. So it's useful to just kind of understand, like, for those people who are carrying over from the old system to the new system, it's good that they now have a new system which is legislative, but how do the directions now become legislative?
Madam Chair. The Honourable Louise Upston. There are no ministerial directions.
The Honourable Priyanka Rahakrishnan.
Just back to the review, and I thank the Minister for her responses there, that the review will look at the impacts or the effects of support programs as well, and not just the primary legislation alone. I would then like to ask her who will carry out the review. Will disabled people lead that review, or will they be part of that review? And I would also like to know whether the terms of reference for that review will be made public before it's undertaken, and whether they will comply with the UNCRPD as well. I would also like to ask the Minister how she is going to measure improvement. So if this is foundational legislation and we don't really have a baseline, I guess, of how it's working for disabled people outside of what they tell us, and even that is not codified in terms of a baseline, how is given the Minister has said that her intention through the review process and the report is to improve the lives of disabled people and carers, how will she measure that?
Madam Chair.
The Honourable Louise Upston.
I would expect that the terms of reference for the review includes the disabled people's organisations, similar to the consultation around support programs. There are other pieces of legislation that have been reviewed, and I would expect that this would follow a similar course.
Aaron Williams.
Thank you, Madam Chair. My question to the Minister is, I understand that her answer is that there are no directions because the directions are a creature of her new 10. What I'm asking her is, and I'll put to her a real-world example of a constituent of mine for things which operated like the directions under the old system. I understand why you're doing this, Minister, that we need a legislative framework for the sorts of instructions that ministers need to give for the programs and the systems for disabled people to access the services that they require. And this is a good piece of legislation in that it at least does give legislative form to what are appropriately laws. In a situation that my constituent had, they were trying to use funding that they were entitled to for a trip which was rightly funded within the rules and instructions, but the question that ended up going all the way up to the top level of MSD was whether the sort of trip that they were asking for was within the remit of the policy intent. All of the instructions said that they could have this kind of trip for their well-being, for their mental health, because it was within their special interest and because they were someone who was entitled to support for that kind of thing. But the actual policy, all of the policy requirements were met, but the question that ended up being needed to be determined at the very highest level of leadership of MSD was whether they were entitled to use it for this particular kind of trip. And rightly, whether that was within the full scope of the legislative design of the programs. So the question is, those didn't have precedential value before, where a minister or chief executive was being asked to sign off on a particular policy question, where all of the policy intentions were met for someone's program and for someone's funding, but whether this actual particular example fit within the scope of the legislative intent, that is rightly law. You are making it law. Do those decisions in the old system now have precedential value? Are they like law? Or are you going to essentially reissue all of those? So this person who was able to go on a cruise would not be able to in future?
Madam Chair.
The Honourable Minister.
Mr Chair, my apologies. My apologies.
It's the year 2026.
Oh, sorry. So the member from the circumstances that she has outlined refers to the flexible funding policy, and my intention would be that the flexible funding policy would be one of the first support programs because of the improvements we've already made. So there are no rules, there are no guidelines now around flexible funding. Where there is overseas travel, there is a kind of a check and balance, which I think people would expect, but there is no intention to change what the policy is currently, but it is going to be important to put it into a support program. That's one of the first that I want to be in a support program, because we have made improvements from a year ago, 2 years ago, 3 years ago, and I want those improvements to be protected.
Priyanka Radhakrishnan.
Thank you, Mr Chair. Further to what the Minister has said around the review, and I note that she has not responded to how it will be measured, how improvement will be measured. So if there is a way in which it will be measured, it would be useful to hear that. I also want to know what happens in the meantime. So this review now, the transition period's now increased from 3 years to 5 years. The Minister has said that at the end of the 5-year period, when this legislation and its effects are reviewed, that some support programs will be completed and in a position to be reviewed, whereas there will be others that will not, and that makes sense. But in the meantime, if there is harm that is caused as a result of some of those support programs, what then is the mechanism for feedback and change, particularly given that some of those won't be part of the review? And also, would the Minister consider amending this portion to include a requirement for ministers to implement the report? Because currently, as the legislation is drafted, the Minister conducts the review, presumably the Ministry conducts review. There is no requirement for it to be informed by disabled people. I wonder whether the Minister would consider including that amendment in this legislation. And also the requirement then is to consider whether there are any amendments necessary, prepare a report, and then to just present that report to Parliament. Would the Minister consider some sort of a binding amendment there to require a Minister to implement the report once it's published and presented?
The Honourable Minister.
So I just want to clarify the inclusion of support programs in the 5-year review would be so within the transition, my expectation is that all of the support programs will be drafted and in place. But at the end of 5 years, there might be one that's only been in place for 3 months, for example. So it wouldn't make sense to include that in the review because it hasn't been in place long enough, right? So I want to be clear about that. I will ask MSD to put some early consideration into what the starting point might be in terms of being able to measure those outcomes in 5 years' time. I think you raise a good point there, so I will ask for that so that we can make sure we've got a starting point. And as I said before, the review of the legislation, because it is about reviewing whether or not the legislation has delivered as intended, it would of course include disabled people in that. As I said before, to me it would make sense in the first stages of that, which includes confirming what the terms of reference for the review would be. I don't think it's useful for me in this House now to kind of dictate how that review would work, who would be involved, over what time frame, etc. But I would have thought any member in this House and any minister who's responsible at that time, given that there is a very strong interest by all of us in improving the lives of disabled people, their carers and families, would want to make sure that those changes are made.
Carlos Chung.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour say aye. Aye. To the contrary, no. The ayes have it. A party vote is called for. Please conduct a party vote.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te ko ngā pōti whakahei.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E whānau pōti whakahei.
Tāka Te Whirus.
Ko tahi te pōti whakahei.
Mea Mino Kapakingi.
Ko tahi te pōti whakahei.
The ayes are 67, the noes are 50. The question is agreed. The question is that part 3 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te ko ngā pōti whakahei.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E whā ngā pōti whakahei.
Tāka Te Whirus.
Ko tahi te pōti whakahei.
Mea Mino Kapakingi.
Ko tahi te pōti whakahei.
The ayes are 67, the noes are 50. The question is agreed. The question is that Schedule 1 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Please conduct a party vote.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te ko ngā pōti whakahei.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E whā ngā pōti whakahei.
Tāka Te Whirus.
Ko tahi te pōti whakahei.
Mea Mino Kapakingi.
Ko tahi te pōti whakahei.
The ayes are 67, the noes are 50. The question is agreed. Question is Schedule 2 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Please conduct a party vote.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te ko ngā pōti whakahei.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E whā ngā pōti whakahei.
Tāka Te Whirus.
Ko tahi te pōti whakahei.
Mea Mino Kapakingi.
Ko tahi te pōti whakahei.
The ayes are 63, the noes are 50. The question is agreed. Sorry, the ayes are 67, the noes are 50. The question is agreed. Members, come now to a final debate. Clauses 1 and 2, title and commencement. The Honourable Priyanka Radhakrishnan.
Thank you, Mr. Chair, and thank members and the Minister for quite a wide-ranging back and forth today that has clarified a fair bit as well. However, I do think that, the title of this bill is the Disability Support Services Bill, and it's reasonably vanilla, but I would include in brackets after services and before bill just the status quo. This is the Disability Services, Support Services, just the status quo bill, because the Minister and the Chair had the opportunity to transform the disability support services landscape. And she has chosen not to. She has outlined her reasons why, and that is we have a difference in approach, and that's really what it boils down to. On the side of the House, we were in the process of transforming disability support services to such a point where the starting question to access services is not what support do you need, but what does a good life look like to you? And then transforming the processes and the systems that sit behind the funding lines and funding streams to be able to then deliver a package of support that would make meaningful difference to disabled people, carers, and the disability communities more broadly, to ensure that disabled people have more choice and control over the services and supports that they access, that they are supported by the state to live with dignity and independence as far as possible. And this bill really just codifies, instead of us as a society moving in that trajectory, all it does is to codify a system that is fragmented and not working for disabled people and carers. And therein lies my disappointment with this legislation, where when we have an opportunity in this House to make things better, all we are doing is to legislate for the status quo that we all know doesn't work. So that is the crux of why I feel that this bill should be titled slightly differently. It could also equally be the Disability Support Services Not Transformational Bill, because ultimately it doesn't achieve any sort of transformation. The Minister's point is that once we're done with another 5 years of then putting into secondary legislation the detail of what is currently available, then we can get to a point of transformation. But I would argue that disabled people have been waiting a very long time for that change. 20 years odd since Enabling Good Lives as a uniquely New Zealand approach was developed to deal with some significant failures in the sector and in terms of disability support services back then. And here we are today, where we also could argue that this is the disability support services actually taking us backwards, Bill, because the assessment and allocation tools that the Minister has talked about in this committee stage today takes us back to the lowest common denominator. It doesn't progress us. She has talked about it in terms of increasing consistency, and I would probably agree with her that maybe it does go some way in increasing consistency, but it increases consistency and certainty not in the way that we would have liked, not in an aspirational way to improve lives, but just to ensure that everyone gets the access to basic supports that don't actually make a huge difference. Well, not that it doesn't make a huge difference for them, it does. It is important funding, but it could have been better. And instead, we're legislating to bring it down to the lowest common denominator. And that is very disappointing, Mr. Chair. I will take the Minister's points that there are certain changes that have been made, and the Select Committee supported some changes because of the significant pushback from disabled people, and pressure is a good way to put it. There was significant pressure from disabled people who had not been consulted at the start of this process that has now led to some changes that are good, but they don't go far enough.
I just note that that was probably a third reading speech, and that any other contributions won't be given quite the same largesse as that one was given. Ricardo Menendez-March.
Thank you, Mr. Chair. I've got a question to the Minister on the commencement date. Does the Minister think that the commencement date is fit for purpose based on the feedback that we have received from disabled people who have felt excluded throughout the process and have only had limited ability to give input in the Select Committee stage through oral submissions? I ask this because the commencement date in and of itself could give the minister an opportunity to say, let's pause this, let's potentially continue now hearing from disabled people, not just through the select committee stage, which disabled people have talked about how it was insufficient because it was a truncated select committee process. And so I'm curious to know whether the minister is satisfied that the commencement date as it stands adequately takes into account the feedback that she has thoroughly received from disabled people, advocacy groups, carers, that they haven't been able to co-design this bill with her. Would she be open to amendments to the commencement date to give her a bit more time to adequately engage with disabled people so that they can, and carers who can then give input on whether the provisions in this bill actually reflect their aspirations? Because ultimately, I know that throughout the debate, she dismissed a lot of sort of concerns by nature of just saying, well, nothing is changing, but that's kind of the point, right? Disabled people and carers have told us that the status quo isn't working for them, and to simply keep things the same, in my view, does not adequately reflect the feedback we've received from disabled people. And I am just concerned that the way in which we've got this commencement date in this bill and the rush with this process reflect more an aspiration from the minister to be able to, claim stake at creating a legislative framework from disability support services, as opposed to actually honour disabled people's and carers' voices along the way. So curious to know if she would be supportive of any tabled amendments we could put in this moment to act in good faith and honour the feedback we've received of actually co-designing this bill, because as has been noted by both the Green Party and the Labour Party, our commitment has been to sort of scrap this and start the process again. But, we don't have to. Like, we could actually just delay the commencement date, go back to as much as we can to the drawing board and actually perhaps refer this back to the select committee and actually do it justice. So I guess my question is, why the rush? And why the rush when disabled people have told us that they'd rather us take the time that we need to design this well. And I think that to me would prevent what has happened actually, which was the minister coming out of the select committee process apologising for the grief that she caused to disabled people. And disabled people had a right to actually be upset about this. But I would loathe for the minister to have to come back and apologise for, say, for example, ongoing or unintended harm that this bill may be causing to carers and disabled people. And so on the commencement date itself, I just think that I want the minister to put it on the record as to why she thinks there is a rush, despite a multitude and a variety of disabled people's voices telling us that the process has been fraught from the get-go. And I want to reiterate that I am by no means claiming stake that there's a monolithic voice in here, but I would say that I have met National Party, Labour Party, Green Party, the odd New Zealand First and Act Party voters who are disabled who have not supported this process. And so I don't think this is so much a sort of partisan issue as it is about a community that has, through its multitude of voices and experiences, told the government this process is fraught. So why not at least end this legislative process, delay the commencement, so that we can actually then potentially go back to the select committee or adequately canvass disabled people's voices, so whatever comes out of it is fit for purpose. I just don't think that so far where we've got into adequately reflects disabled people's voices, aspirations. And even if we look at some of the previous parts of the debate, we did not even get adequate engagement or any engagement on, for example, like, why could the minister ignore, the need to consult the disabled people's representatives and the design of disability support services. So in good faith, I'd ask the minister to offer us any reflections on whether she'd be open to delaying the commencement to do this bill right.
Point of order, William.
Thank you, Mr. Chair. I want to draw your attention to Speaker's Ruling 1273 on page 127 of the Speaker's rulings. Just in relation to your guidance that I understand wasn't a ruling, but leaves us in some trouble here because we have a number of engaged spokespeople from the opposition who wish to give concluding remarks on this bill. And Speakers Hartley, Robertson and Tish have all affirmed the latitude of the opposition in making speeches on the preliminary clauses at the end of a bill which summarise and make concluding remarks about a bill, about the issues that they have raised within the committee's consideration of the bill. And I just wanted to clarify, given that it's a new practice in this Parliament for the chairs of committees to give not rulings but sort of guidance to members, which is by and large helpful, whether your guidance there is that spokespeople from the opposition should not give sort of concluding remarks in the committee stage, given that also it was a, say in the 2004 example where Speaker Hartley affirmed that position, that was in a debate where the government had called for called repetition on members after 18 calls that the opposition had made in concluding remarks around a preliminary cause. So I just want to clarify like the level at which you're giving that guidance and whether it is in fact a ruling which disagrees with the remarks of Speakers Hartley, Robertson and Tish.
Absolutely not. Any wise and experienced speaker will ensure that if they are speaking to the title and commencement, that they will make more than a passing reference to it at different stages during a 5-minute presentation. There is always some latitude. Also, the amount of repetition that if a series of speakers stand up and say the same thing. So it will be, each presentation will be taken on its merits, but any wise speaker would be making some, especially when they're the third speaker in this series, would make some fairly constant reference to title and commencement.
Mr. Chair.
Or to invite a closure motion. Alana Williams.
Mr. Chair, thank you. Mr. Chair, I would like to speak to the title of this bill, the Disability Support Services Bill. It should be titled the Enabling Good Lives, Constituting and Reforming the Legislation Bill. And I'm proposing to the House that that title should have been commensurate with what was in the bill, because this bill should have given effect to the policy that is transformational and would have impacted the lives of disabled people in Aotearoa and was something that New Zealand could have been proud of on the world stage. But in fact, this bill does the opposite of that. It reverses the policy that disabled people have been calling for 20 years. And I would suggest to the House that this is the stage that it should vote with the opposition to not only change the title of the bill, but reject the rest of it. Because this is a bill, Mr. Speaker, which changes New Zealand's framework for the better, but introduces a policy which is all wrong. I find it difficult to talk about this bill. This is a bill which is not my specialist area. I commend the Honourable Priyanka Christian for her work in this area. It is not my area. But this is the area of government reform which I find the hardest to see and hear in this House, because I think it is all in the wrong direction. And I think if there is one thing that should be bipartisanly agreed in this House, it is that disabled people should be able to live with dignity in a country like Aotearoa's, and that when they do not have the means to provide for themselves, that the state should step in. That is a fundamental belief of mine, and it should be carried forward in any country that likes to call itself one where people have equitable and equal access to their rights as citizens. This is more fundamental than any other change, I believe, that this government has made, because this says that we are moving from a system where disabled people and our most vulnerable can rely on a social safety net, one that was agreed after war in the 1940s in most liberal democracies that we like to compare ourselves to one which they cannot, where there is uncertainty in the law, which in the sorts of services that they will be provided with, where there is almost entirely ministerial discretion, because it will come down to first in, first served, and most in need gets, without any kind of fundamental relationship to the idea that people with disabilities and their families should be able to rely on a fundamental standard of dignity with which to live their lives. I walked out onto the street in Manarewa the other day. It was about 12 o'clock, and there was a chap there, his name is Hone, who was waiting for a taxi to pick him up. He used a crutch and he had a small carry-on suitcase with him for the things that he needed to go about his day. And when I walked out again after my meeting at about 1:20 p.m, he was still waiting there. And I had a conversation with him about why he was waiting, and he said that the taxi won't pick him up and that he's spoken to the taxi driver twice, but because of the changes to total mobility, he understands why the driver won't pick him up, he understands why the driver has other jobs to do, he understands why it's not profitable for that driver. And yet he waited an hour and 20 minutes. The changes that are happening in this system mean that people like that are living worse lives. This bill does that. This should be a different bill. This should be a bill which outlines the New Zealand government's long-term commitment to people with disabilities. It should outline our bipartisan, long-term intentions to enable them to live lives with dignity. It does not do that. And I hear the government asking, what is the question? My question is, where is the humanity in this bill? Where is the commitment to the principles that the National Party espouses and will be espouses on the campaign stumps? We will hear them say that they have compassion for people in Aotearoa. We will hear them say that they believe in the kind of future for young people where they want to stay here and build good lives. This is it too. It's not just about the people who can afford to provide for themselves. It's not just about the people who can aspire to own a home and live the kind of lives that we would all want them to. It is also about their brothers, their sisters, their kaumātua kuia who cannot provide for themselves. And at the end of the day, if they cannot rely on the state, whichever colour it is, blue or red, to fight for those people and to advocate for them and to stand in when they cannot provide for themselves, then that is a fundamental change in the way that we do things here in Aotearoa. This is that bill.
Ms Williams, you've taken a liberty. I'll take it close. Oh, Minister. Honourable Minister.
Mr Chair, we won't be changing the name and title of this piece of legislation. We will not be changing the commencement date. And I want to explain why. Because the lives of disabled people in New Zealand are frankly not good enough. They are not served well enough by not just the Disability Support Service, but government agencies across the board. That's why it is important that this legislation is passed so that continued improvements can be made to the lives of disabled people, their families and carers. In terms of the principles of enabling good lives, they are very much at the heart of this legislation, which is why it is important it is passed and that it commences. And significantly, some of the improvements that have already been made by this government in increasing funding over both budget 24 and 25 in areas of flexible funding where there are now no rules and no guidelines that are having a significant improvement over the lives of disabled people. This is important, Mr Chair, that we pass this legislation and we get on with the improvements that disabled people deserve.
Mr Chair. Joseph Mooney.
I move the debate is now closed.
The question is the debate on this question now closed. All those in favour say aye. Aye. The contrary no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
11 votes opposed.
ACT New Zealand.
11 votes in favour.
New Zealand
8 votes in favour.
Te Pāti Māori.
4 votes opposed.
Tākuti Ferris.
1 vote opposed.
Miramano Kapkingi.
1 vote opposed.
The ayes are 67, the noes are 51. The question is agreed. The question is that clause 1 stand part. All those in favour say aye. Aye. The contrary no. The ayes have it. Did actually you call no? All right, okay. A party vote is called for. Please conduct a party vote.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
11 votes opposed.
ACT New Zealand.
11 votes in favour.
New Zealand
8 votes in favour.
Te Pāti Māori.
4 votes opposed.
Tāku Te Whereas.
1 vote opposed.
Muramana Kapakingi.
1 vote opposed.
The ayes are 67, the noes are 51. The question is agreed. The question is that Clause 2 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. A party vote is called for. Please conduct a party vote.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
11 votes opposed.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
4 votes opposed.
Tāku Te Whereas.
1 vote opposed.
Muramana Kapakingi.
1 vote opposed.
The ayes are 67, the noes are 51. The question is agreed. I'll report this bill without amendment. Thank you.
Thank you.
Thank you, official.
The House is resumed.
Madam Speaker, the committee has considered the Appropriations 2026-27 Estimates Bill and reports that it has made progress on the bill. The committee has also considered the Disability Support Services Bill and reports it without amendment. Madam Speaker, I move the report be adopted.
The question is that the report be adopted. Those of that opinion, please say aye. Aye. To the contrary, no. The ayes have it. The Appropriation 26-27 Estimates Bill is set down for further consideration in committee next sitting day. The Disability Support Services Bill is set down for third reading next sitting day. I call on Government Order of the Day number 3.
Social Security Job Seeker Support and Accommodation Supplement Amendment Bill, second reading.
The Honourable Louise Upston.
I move that the Social Security Job Seeker Support and Accommodation Supplement Amendment Bill be now read a second time.
That legislative statement is published Oh, sorry. No, okay. Very good.
Madam Speaker, as I've said before, our government believes that the welfare system should be a safety net for those who need it most. It should be there to support people when they generally need assistance, while encouraging those who can support themselves or who can reasonably be supported by their families to do so. New Zealanders deserve a welfare system that is firm, fair and simple, and that's what this bill does. The Social Security Job Seeker Support and Accommodation Supplement Amendment Bill amends the Social Security Act of 2018 to support fiscal sustainability in the welfare system by better targeting financial assistance to those most in need. As I outlined in the first reading, the bill has 2 policy components. Firstly, the bill tightens the eligibility criteria for job seeker support and the equivalent emergency benefit for 18 and 19-year-olds by introducing a parental assistance test. When this initiative is implemented, young people will need to meet the parental assistance test criteria before they can access or continue to access one of those benefits. The initiative will reinforce the expectation that young people who are not in employment, education or training should be financially supported by their parents instead of relying on the welfare system. There has been an increase in benefit dependency among young people. As of 2017, modelling has indicated that 18 and 19-year-olds on job seeker support were projected to spend an average of 12 future years on a main benefit. However, more recent modelling indicates that this estimate has increased to an average of 21 future years supported by a main benefit. That is why our government is building a more active welfare system that supports more young people into work. Going on welfare when you're young is a trap, and it's not the future our government wants for young people. To meet the parental assistance test criteria, a young person will need to demonstrate that they have a support gap with their parents, meaning they cannot reasonably be expected to rely on their parents for financial support and/or their parents' incomes fall below the income limit. The support will be there for those who need it under this test. Secondly, the bill targets the accommodation supplement more tightly for some homeowners. It increases the minimum weekly contribution some homeowners must make before they are eligible to receive the accommodation supplement. I would like to thank the Social Services and Community Select Committee for its careful consideration of the bill, and to those members of the public and organisations who provided both written and oral submissions. The Select Committee received a number of submissions that commented on the parental support gap for job seeker support. To be clear, the parental support gap test has been designed as a safety net to ensure that where parental support is not available or cannot reasonably be relied on, those young people will remain eligible for support. This test allows for a young person to provide relevant evidence to MSD to determine a parental support gap. Some submitters raised concerns about the lack of details in the bill around the parental support gap test, and I acknowledge those concerns. The detail will be set out in secondary legislation as provided for in the Social Security Act. This will be gazetted and published in the House to set clear and consistent guidelines for verification of parental support gaps. The secondary legislation will include the types of evidence that MSD can accept, criteria for who can verify a supporting statement, and the circumstances when MSD can nominate someone to verify a parental support gap. There were concerns about the impacts of the policy on those with disabilities. Firstly, impacted young people will continue to have access to supplementary payments from MSD, such as a disability allowance where they are eligible for support. I want to make it clear that the supported living payment is not in scope of this policy. This means no parental assistance test is required for young people who have a health condition, injury or disability that permanently and severely restricts them in their ability to work. Rather than being on a job seeker support, young people will have better future outcomes if they remain close to the labour market. To do this, the parental assistance test will apply to all grounds of job seeker support to encourage young people into employment, education or training. For the accommodation supplement entry threshold change, many submitters were concerned that older and low-income homeowners may be impacted. I want to reassure the public that the entry threshold increase is not applied to New Zealand superannuation, the veterans pension, supported living payment and emergency benefit equivalent recipients or their partners. Our government acknowledges that the circumstances of these recipients are less likely to change and they are likely to require longer-term social assistance. Generally, homeowners with the highest accommodation costs and those with the most support will not be affected by the entry threshold change. Several technical amendments were agreed through the Select Committee stage, and these provide greater clarity and ensure the legislation operates as intended. After its consideration of the bill, the Social Services and Community Committee has recommended the bill proceed. Mr Speaker, this bill ensures that financial support is targeted to where it is needed most. It encourages young people to move into work, study or training. We will continue to support New Zealanders who have no other means of support available to them. But when individuals or their parents are able to provide that support, our expectation is that they should do so, not other taxpayers. I am confident that these changes will lead to better long-term outcomes for 18 and 19-year-olds and to support being provided to homeowners who need it the most. I look forward to seeing this bill through the remaining stages of the parliamentary process, and I recommend and commend this bill to the House.
Question is the motion be agreed. The Honourable Willow Jean Prime.
Tēnā koe I te māngai o te whare. The Minister in her contribution talked about it being firm and fair and statements like a more active system that supports young people into work. Labor opposes the Social Services Job Seeker Support and Accommodation Supplement Amendment Bill. This bill is yet another attack on people who are doing their best but are struggling to get by because of this government's choices and that this government is doing nothing to help them. Every day this government is in power, their choices make it harder for people. Instead of helping New Zealanders get ahead, we've got Christopher Luxon promising to fix the cost of living while his government continuously makes choices that are making it worse. And this bill is one of those bad choices. We've already seen national/temporary additional support and make it harder for emergency housing. And this week, Mr. Speaker, we learnt that thousands of pensioners and veterans lost access to their winter energy payment because the Minister was in such a rush to put through that legislation and make life harder for people. And now we have this bill. I focus on the impacts of this bill on young people, but I want to note how detrimental the changes to the accommodation supplement will be for low-income earners in a cost of living crisis as well. But turning to young people are suffering because there are no jobs for them. According to the Salvation Army, in the year to September 2025, the number of young people not in education, training or employment was higher than it has been in 20 years. Many of these young people need job seeker support to get by, and this government wants to take that support away. So what does this bill do? This bill makes it harder for rangatahi aged 18 to 19 years to access job seeker. These are young adults stepping out into the world and trying to make independent lives for themselves. But this bill cuts them off at their knees and undermines their ability to exercise their own agency and develop as adults. Many have already had a lot of negative experiences in their lives. Moving into independence is a crucial step, but this bill undermines it. Mr. Speaker, I want to point out for the House the government's own document that summarises this situation well. And I want to read into the Hansard because I think that every member of the House should hear this. The regulatory impact says, in terms of impact on young people and their families, the costs will significantly outweigh the benefits. That's not the Labour Party saying this. This is the Ministry for Social Development that is saying this, and the government proceeds anyway. Mr. Speaker, we oppose this bill. The Minister acknowledged those that had taken the time to make submissions and highlighted some of the issues and concerns in those submissions. Well, I note for the House today that 933 submissions were in scope and received by the Select Committee. Only one supported the bill. One. That's not a close call, that's a verdict. Let me tell the House what some of those submissions said, because they deserve to be heard, even if this government chose not to listen and to dismiss those concerns. The New Zealand Council of Trade Unions, who represent over 370,000, oh, look at the laughs and the eye rolls on the other side because I mentioned that dirty word union to the other side. Well, they told the committee they represent over 370,000 workers, and they told the committee plainly that the bill will not achieve the stated intention of reducing benefit dependency among young people. In fact, they highlighted that youth unemployment has risen significantly. Oh, Minister for Youth over there. Maybe you might want to listen to this. But what they were at pains to point out is that this is not because young people have suddenly become lazy or uninterested in working. It's because they are trying to find work and there are just no jobs. On top of this, young people generally have fewer skills and less experience simply because of their age, and the work that they are trying to find is concentrated in industries like hospitality and retail. Well, what's happened in hospitality since this government came into power? They have been some of the most hardest hit industries in the economic downturns. I want to turn to the New Zealand Council of Christian Services, who also detailed that the changes for young people finding work, like we've heard across the submissions, they pointed out that this bill will lead to increased financial hardship among whānau who become financially responsible for young people unable to access work. Their first recommendation was simply this: do not proceed with it. Did the Minister listen? No. What about the Salvation Army? They have worked for over 140 years, supporting around 130,000 people every year. And they told the committee, Mr. Speaker, that this will only add complexity into what is already a highly complex system for vulnerable people to have to navigate and will make life harder. They also pointed out that this will reduce young people's access to the very services they need to get jobs, that is, employment support and training, things like helping with literacy and getting a driver's licence, which we know are the reasons that stop young people from getting work in the first place. So the Minister in her contribution said that this will be about a more active system that supports young people into work, but what submitters told us is that if they are not on the job seeker benefit, then they have no access to those very supports that they need to help them get into these jobs, or ghost jobs, because where are all the jobs, Minister? Then we have the Citizens Advice Bureau. In their submission, they referred to the government's stated aims, which is to reduce benefit dependency, and they showed how this is at odds with the reality. Most young people who receive job seeker support are already actively seeking work. And they gave an example of Maya. Maya had a job she enjoyed in hospitality, but the business closed due to the recession and she lost her job. She has been looking for work, but due to limited opportunities, she has enrolled to study. She has run out of funds and with no work needs to apply for support. So the Citizens Advice Bureau emphasised what other submitters said. Young people who come to the Citizens Advice Bureau are not choosing benefits over employment. They are navigating insecure labour markets, rising housing costs, increasing food prices, transport barriers, mental health challenges, and limited opportunities. Mr. Speaker, I also turn to the submissions that we received for the impact that this will have on Māori. That was from Te Hungaroia Māori, the Māori Law Society, and Po Tangata on behalf of the National Iwi Chairs Forum. In Te Hungaroia Māori Society's submission, they talked about how this had been developed, once again, without any engagement or meaningful engagement with Māori, despite the foreseeable impacts on Māori communities. As they state, this is inconsistent with the Crown's obligations under Te Tiriti. Meaningful engagement requires Māori participation in a formative stage of policy development, not after things have already been settled, and they submitted that the bill should be withdrawn. We agree with that. The government didn't. Po Tangata also said forcing rangatahi to legally declare their parents cannot support them places an undue burden on whānau relationships, creating internal friction and shame within households already under financial duress, and ignores the reality of Māori communities that Māori communities face under the national employment rate, which is that the Māori unemployment rate is double that of the rest of New Zealand, the general unemployment rate. Mr. Speaker, the Minister talked briefly about the impact on people with disabilities, and that came through again strongly in the submissions. And just like she ignored the submissions in the previous bill, she's ignored them here too. Mr. Speaker, these are some of the reasons why submitters and Labor oppose this bill. The most effective way to support young people into employment is education, training and tailored employment services. Not punitive income tests, not parental means testing. We would invest in young people on this side of the House, Mr. Speaker. This government is divesting from them. So 930 submitters told this committee the bill should not proceed. Labor agrees with them, but that side of the House just ignored it.
Mr. Speaker.
Ricardo Menendez-March.
The National Party is all about breaking the basics and ruining the future for young people. And this bill is just the latest example of their ongoing beneficiary bashing, attacks on the poor, while they cut thousands of jobs and leave children growing up in poverty with worsening material conditions. That is not my view. That is the fact. The government has been told that as a result of decisions that they have made, more children are growing up in households where they do not have enough to meet their basic essentials. And Mr. Speaker, tell me how cutting benefits for thousands of sick, injured, and disabled young people fixes the basics. Tell me how pretending that sick and injured and disabled young people who have been deemed by work and income to not be able to work full time will just magically be able to transition into training or education. Tell me how a young person who is seeing a hiring freeze on our public healthcare system will be wanting to go into a healthcare profession, only to find themselves with a massive student loan and no job to go into. None of the provisions of this bill help address the basics, which is that we've got a government that has been focused on cutting jobs rather than creating them, that has been focused on worsening material conditions for students rather than improving them, that has been focused on stripping the sick and injured and disabled people of the support that they need instead of improving it. The minister in her previous speech on the previous bill conceded that disabled people have it hard. Well, then why cut thousands of sick and injured and disabled people's income support as part of this bill? Thousands of people on job seeker, health, injured, and disability will be affected as part of this bill. And for any member of the government who will say, oh, they can just go on the supported living payment, I urge you to go out to the streets. Talk to a bloody single beneficiary for once, and talk to them about the challenges that they face getting on the supported living payment. Talk to them about the fact that they face humongous hurdles trying to get into a benefit that has huge barriers, not just because it requires you to be able to afford the cost of going to a GP, it requires you to go to a GP that, for example, will actually be cognizant and competent on disability issues. And it requires work and income to choose to not challenge a doctor, a trained medical professional, with a board that can often have people who haven't practiced for years to basically decline the comments from a doctor. And it should come as no surprise that we've got members from the ACT Party, for example, further wanting to restrict access to the supported living payment. I'll tell you, Mr. Speaker, who exactly is having their incomes taken away from them. And this is coming off the Select Committee's own documents. We've got people who are facing psychological or psychiatric conditions. That's almost 70% of the people who are on job seeker, injury, health condition, or disability. So much for a government that cares about our youth mental health crisis. We've got people who are facing cardiovascular disorders, who have faced accidents that have left them unable to work, complications of trauma, pregnancy-related issues, congenital conditions, including cancer, infectious and parasitic diseases, musculoskeletal system disorder, respiratory disorders, genitourinary disorders, blood and blood-forming organs, skin disorders, digestive system disorders, nervous system disorders, immune system disorders, metabolic and endocrine disorders, intellectual disabilities, sensory disorders, and other conditions. Tell me why cutting the benefits of people who are facing these conditions does anything to fix the basics other than ruining their lives. Cutting income support for people who are sick, injured, and disabled worsens their health conditions. And I find it so galling and telling that the minister, when I've asked her in question time about this very same serious issue, she goes, oh, well, people can still access hardship grants for food. So you're telling families that they should go and line up at food banks and work an income to continue to survive while their kids are sick, injured, or disabled? What kind of safety net is that? What kind of future are we trying to provide for young people who are unwell? Their health conditions and their injuries will not improve as a result of cutting that very same income support. You will worsen them. It doesn't take an expert to know that if you're injured or sick and you deprive people of that support, you'll be leaving them worse off. And then the minister talked about, oh, well, don't worry, there's a parental income test. How much is the parental income test? It's $67,000 total as a household. That means that if you're deemed to earn as a household over $67,000, that means, for example, two parents' combined incomes, you won't be eligible for a benefit. Tell me what family in this cost of greed crisis can actually afford their basic essentials with two parents, perhaps two children, with a total combined income of $67,000. Not many. It just shows that this government is completely out of touch with the lived realities of working families, putting more pressure on parents who are simply trying their best, while also stripping those parents of the support that their children would have been eligible before they turn 18, It just does not make sense. And if we look at some other components of the bill that cut accommodation supplement for low-income homeowners, it tells you exactly who this government is serving. Because they have rushed legislation to support property investors, but when it comes to low-income people who have maybe finally saved enough for their first home, yep, we're stripping them of support. How much? On average, $40 a week. $40 a week for a low-income family actually is the difference between being able to keep the lights on or put food on the table. And the people who they're cutting support from includes people who are in work. In fact, the large majority of people who are affected by this of a single group are non-beneficiaries. So they're not just targeting people on the benefit, they're targeting working families. But it also includes solo parents who perhaps finally managed to build a life, to get a home, and are trying to just pay the mortgage off. It includes people who have become injured or sick as well and have had to go on a benefit temporarily. And we're not talking about the 18, 19-year-olds who the minister continuously and erroneously claims that they're going to be, she kind of presents it as 20 years continuous on the benefit. We're talking about people who may just need support for a handful of months while they get better. But I guess it's okay. Because at the end of the day, the minister says that she's targeting support to those who needs it while claiming $50,000 plus on accommodation benefits herself. Like, that is not serious. Can't take a minister seriously when she says we're targeting support to those who need it the most while she cuts income support for those who actually need it, and she claims tens of thousands of dollars to pay for a property that she does not have debt on. Shame on this government for just showing us who they're serving, which is not everyday working families. Because those 18, 19-year-olds on a benefit, yeah, they're supported by and large by working parents. Working parents who this government is choosing to make their life harder. And again, I just cannot see how government members on the other side will give us their 10-second contribution telling us that this is a bill about fixing the basics and building the future, as though it was a ChatGPT-produced speech, when they're doing the exact opposite. They cannot even tell us how exactly this bill will reduce the number of years that someone spends on a benefit, other than just simply by taking that benefit away. It's not because they created better employment outcomes, and we know that. Because young people are applying for countless of jobs. We've got news stories of jobs that have had hundreds, if not over 1,000 applicants. We know that in this economic system, unemployment is baked in by the sign. No matter whether it's labor or national and government, unemployment has been a fixture of the economy. You will not tell us that you've got a national party that wants to reduce unemployment to zero. It's not correct. They don't want to. They never wanted to. They have never, ever stated that their intention is to reduce unemployment to as close as 0% as possible, because they have always intended to have a group unemployed living below the poverty line, desperate to take any job no matter how poor the conditions are. And when you compound that with a legislative agenda that has worsened conditions for low-income workers, it tells you that this isn't a government that is ruling for working families, but instead their mates who are actually benefiting from the policies that they're putting forward, whether it's people in the fossil fuel industry, whether it's property investors. The Green Party is committed to repealing this legislation and building a safety net that actually provides tailored support for young people who want to go into education, who want to go into training, who want to get a job, and a safety net that honors the dignity of people that are injured, that are sick, and are disabled, rather than taking those very benefits away. I dare for those members of the other side to justify taking benefits away from cancer patients or people who are struggling with psychiatric conditions. Justify it. Look at the Select Committee report and tell me that you don't know that you're actually taking benefits of thousands of people who are sick, injured, and disabled away. Tell me that you don't know. Justify it. I dare you.
Laura McClure.
Thank you, Mr. Speaker. Firstly, in response to the previous member's comments, this bill does not take away the supported living payment for those with the likes of cancer and a lot of the conditions that the previous member spoke about, or the disability support. There were submitters that came to us that they had been whipped up in a fear that this would happen by, quite honestly, members from that side of the House. And is not what is happening with this piece of legislation. We cannot unlock the potential of the next generation if we say that it's okay to be at home and not in educational work. That is completely not acceptable. This side of the House and the ACT Party has way bigger ambitions and goals for our young people, and we will not allow them to just sit at home. If you're a student and you're in education, your parents' income is tested before you get student allowance. How is it fair that an 18-year-old could get the job seeker payment and that not be income tested? We are not saying that you can't go on job seeker if you don't have parental support. We are merely saying that if you do and you're living at home and you're with your parents, that you have to have that income tested. And I think that is actually fair and reasonable, because we can't have young people not in education and not in work. They still have the other supports that MSD offer around helping getting young people into work, which I think is a really important thing to note. CV help, matching them with employers, all of that still exists under this legislation. And when it comes to the accommodation support, yes, the criteria has changed, and that means that some people that own their own home may have a reduction or will have a reduction in the amount that they get for their accommodation support. But think about the people that don't own their own home, the ones that are way far behind. They're going to be receiving an extra $30 a week, I think it is. Well, I think it's between 10 and 30, depending on who they are. We can clarify that. But they will be receiving an additional payment in the next coming month. So I think that is really important to acknowledge that nothing has been cut here. We are actually redistributing money to those that really desperately need it, and we are not going to incentivise staying on a benefit if you're 18, because we actually care about the next generation. We want to unlock their potential, and we're not going to do that if they're sitting on the couch playing PlayStation at home with mum and dad. Commend this bill to the House.
Point of order, Ricardo Menendez-March.
Thank you, Mr. Speaker. I seek leave to table pages 12 and 13 of the advice given to us by MSD that shows that there are thousands of people with health conditions affected by this bill.
As a select committee document, that is readily available to all members.
I'm not aware if it's been published, but it seems like they're not aware of it.
Oh, leave is sought for that purpose. Is there any objection? There is.
Okay.
Jamie Arbuckle.
Thank you, Mr. Speaker. I rise on behalf of New Zealand First to support the Social Security Job Seeker Support and Accommodation Supplement Amendment Bill. One of the first priorities for New Zealand First is the employment of New Zealanders, and that is in our planning a priority and one of the first things we think about as a party in this government. Mr. Speaker, I was able to sit on the Social Services Select Committee for this. We heard 87 oral submissions, over 935 submissions in total. But I do agree with the Minister, the welfare system is a safety net, and the first priority here is looking at the job seeker. It's about the eligibility criteria for job seeker and the emergency benefits for those aged 18 and 19 years old. And in the first reading speech, I talked about our young people are our future, and they are the people that we want to see firstly in work or education or training. And that's the principle here, that we want to see our young people, if they are either in work, and if they can't find work, they are in education and training. We do not want to see our young people on job seeker benefits and becoming dependent on benefits. And what we learnt and have learnt, Mr. Speaker, if young people start on benefits at a young age, their dependency can be up to decades. And as a country, we want to be a productive country, and to be a productive country, we need our young and brightest people to be in training, education, or they need to be in work. So it's a very simple process from this side of the House. The second part of this bill was the entry threshold for the accommodation supplement. Again, Mr Speaker, it was very clear that this hadn't been reviewed since 1993. So obviously the threshold here is increasing from 30% to 40%, but proudly New Zealand First, we want to highlight that it will not impact New Zealand superannuation, and it will not impact those on the veterans' pension. So this is a very common sense update to this bill, getting our young people into work. That's what we strive for in this country and on this side of the government. Hearing from the opposition, it sounds like they want everybody on the couch and going to the ATM machine every week to get their money. On that, Mr Speaker, I commend it to the House.
Mr Speaker.
5 minutes for call already, Kaipara.
E te pika I give rise to the voices of those who are looking after rangatahi on the front lines, especially in Tāmaki Makaurau, and the question is, where do they go? The Minister and their government still cannot answer that. When an 18-year-old has no job, no income, this government is asking, how much do your parents earn? How much does mum and dad earn? I'm asking something very different. Are you okay? Are you safe? How can I help? And what can we do right now to stop you from being homeless? That's the difference between this bill and my youth homelessness prevention bill. At first reading, I warned this House about the assumption sitting underneath this very policy, that every rangatahi has parents who can support them, that every home is safe, that every whānau has money to spare. Well, guess what? They don't. A parent's income on paper isn't a home. It doesn't mean there's a spare bedroom, and it doesn't mean that relationship is safe. In Tāmaki Makaurau, where whānau are already stretched by rent, food, power, transport, medical and dental bills, school costs even, it certainly doesn't mean that there's money left over to support another adult. So when you take income away from rangatahi, from one rangatahi, where are they supposed to go? If they end up on Nan's couch, you haven't solved benefit dependency. If they end up sleeping in a car, you haven't created independence. If they end up in emergency housing or worse, out on the streets, you have not saved the Crown money. And if they end up on the street, every single one of us in this House has failed them. That's why I introduced my youth homelessness prevention bill, because I refuse to accept that we have to wait until a rangatahi is homeless before the state acts. My bill starts earlier, Mr Speaker. See the warning signs, step in, keep them housed, connect them to community, and then help them into education, into training, and then into mahi, into work. That is prevention. That is what social investment should actually look like, not removing a young person from one government spreadsheet and declaring success, because getting someone off a benefit isn't the same thing as getting somebody into a job. And it sure as hell isn't success if we get them into homelessness. So I'm putting this government on notice. At committee stage, I will ask this House to remove the parental income regime, and if the government refuses, I will move amendments to protect our rangatahi. If taking away their income puts them at risk of homelessness, they should keep their support. If the government says they can go home, prove that home exists. Prove that it is safe. Prove that it is actually available to them. And if the Minister genuinely believes that this policy will improve young people's lives, measure what happens to them. Tell us how many enter into work and how many leave work. Tell us how many enter into education and leave successfully. And tell us how many end up needing emergency housing or homeless. Because there's something seriously wrong, Mr Speaker, with the direction that we are heading. This Parliament is considering laws that make it harder for some rangatahi to access income when they bloody need it. And laws that make it easier to move people on once homelessness becomes visible in our public places. You think about that. Make it harder to stay afloat. Then, if they end up on the street, move them on. That's not a pathway forward. We offer one. It exists in this House right now. Don't wait for homelessness, prevent it. House our rangatahi, back our whānau and intervene early. Give our rangatahi, give our young people enough stability to get back into mahi, to get a mahi,
Now,
to get into education.
The member's got 1 minute left. She should refer to what happened at Select Committee, which is the real purpose of the second
I'm
reading.
nearly done, Mr. Speaker. Thank you. Get them into mahi education and training and stop measuring success by how many people we can remove from a benefit. Measure success by how rangatahi never become homeless in the first place. And to every member preparing to vote this bill in, when a rangatahi loses their income, when home isn't safe, when mum and dad aren't an option, where do they go? If you can't answer that question, you have no business taking their safety net away.
Just reminding that member that a second reading bill is required to make reference to what happened at Select Committee, as well as other contextual matters. So members, the time has come for me to leave the chair. The House will resume. The debate is interrupted and set down for resumption next sitting day. The House is adjourned until 2 p.m. today.